The November 13th, 2019 meeting of the Municipal Code Enforcement Board is called to order. I'm the chair, Richard Schmidt. Please stand for the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Ladies and gentlemen, the Municipal Code Enforcement Board is charged with conducting hearings to determine whether an alleged violation of the city code has occurred. Decisions made by this quasi-judicial board will be based on the evidence and facts presented tonight. Our meetings are conducted in accordance with Robert's Rules of Order, and each case will begin with the city presenting its evidence of the alleged violation. The respondents will then present his or her case. Both parties will have the opportunity to cross-examine all witnesses. The board members may question any witness. Comments by both parties must be relevant to the case. Persons wishing to speak will be given an opportunity to do so by the chairman and must address the board from the podium after giving their name and address. Upon request, copies of the material submitted by the staff are available for review. Board members are reminded to obtain permission to speak from the chair, and questions of the city should be directed to the attorney for the city. At this time, I will ask all persons who expect to give testimony tonight to stand and be sworn in by the city clerk.
Please raise your right hand. Do you swear or affirm that the testimony or evidence you're about to give or present is the truth, the whole truth, and nothing but the truth?
Cases will be taken out of order to accommodate respondents and witnesses present here this evening. There will be a 3-minute time limit imposed on all comments from the public. Appropriate address when appearing before the board is appreciated, and cell phones must be turned off during the meeting. Okay, first order of business is approval of the minutes for last month, October 9th meeting. Did all receive copies? Any changes? There being none, call
Move
for
to
a motion
approve.
to approve. So moved. Second? Second by Buckley. Call for any discussion? There being none, all in favor? Aye.
Aye.
Opposed? Nay? No nays.
Case number 1. Case number
Chair, if I could do ex
Oh,
parte.
excuse me. I'm getting ahead of myself. Ex parte communications.
Yes, I'd like to ask the members of the board if they've had any ex parte communications regarding any of the matters coming before the board this evening. If there have been any verbal communications, if you could please disclose the sum and substance of those communications, when and where those communications occurred, and with whom they occurred. And if there have been any written communications, if you please disclose the sum and substance of those communications, and then provide that written communication to the city clerk so that it can be part of the record.
I've had none.
I have not.
Have none?
I have none.
I have had none. I've had none.
Thank you.
Case number 19-4612, City versus Sway 2014-1 Borrower LLC for the property located at 207 Woodbine Avenue. The case is before the board based on alleged violation of Section 622A, Animal Running at Large. The case will be prosecuted this evening by Director Tom Baroni. The city has evidence that the notice of violation and the notice of hearing were properly served.
Good evening. Tom Baroni, Code Compliance. This case this evening originated from 4 neighbor complaints that I received on August 16, 2019, about cats running at large, urinating on private property, odor smell at the front door, a top roof, and overgrown conditions. That same day, I reached out to Invitation Homes representative to update them with the status of their rental property. That same day, I prepared a notice of violation with the compliance date of August 22nd, 2019. I posted the notice at the front door and requested copies to be sent out certified and first-class mail. I also requested a copy to be posted at City Hall for the 10-day requirement. I did receive a phone call from the property manager on August 19th, 2019, to confirm that they received the notice letter. I spoke with the tenant on August 21st, 2019, and we had a discussion how to resolve this issue. On September 10th, 2019, my inspection noted no cats on the neighbor's private property, grass was mowed, front door area was cleaned, and the tarp was removed because the shingles were replaced. I closed the case. On October 10th, 2019, I received an email from the neighbor stating that the cats are still on the property again and that he is tired of the cats using his lawn as a litter box. I reopened the case due to the violation reoccurring within 45 days of the service of violation. I responded to the neighbor's email on October 11th, 2019, and asked him if he wanted to proceed to the code board, and if he did, he would have to bring his neighbors to join him. At this time, I would like to submit photographic evidence of the violation that was taken by the neighbor. Exhibits 1 through 4 shows the neighbor's cats running at large. I'd like to submit at this time.
Without objection, the evidence will be admitted into the record.
Thank you. I'd also like to submit another exhibit number 5, which is a police report that was prepared by a Temple Terrace police officer for the, this is a form that's, it's a disturbance or a nuisance to the neighbors, and I'd like to submit this at this time.
Without objection, the evidence will be admitted into the record.
Thank you. And, Mr. Chairman, when the neighbor comes up to testify, you may want to show him those photos just to verify that he took those photos, because I did not take them, and I did not see the cats on the property. However, he observed them and took it.
Would you retrieve them from
Sure,
the
I'll take
city
care of it.
clerk? Please.
I'd like to bring up the neighbors at this time and let them give their testimony.
Thank you. Well, first, before that,
Okay.
Are there any questions of Tom?
Sure.
I just have one question. Because you closed it and reopened it within the 45-day frame, this is still a first-time violation, correct?
That's correct.
Okay, thank you.
It's still a notice of violation.
Yes.
The pictures that I'm going to show you, sir, are these the pictures that you sent to me by email to me?
Absolutely,
Be-
yes.
Before you comment,
Oh, okay.
name and address,
Okay.
please.
My name's Chris Kreitz, or Christopher Kreitz. I live at 211 Woodbine Avenue in Temple Terrace. And this incident has been going on for years. It's just boiled up to this now.
Okay.
I've counted up to 12 cats on the front lawn. It's owned by a corporation, and the leases, we've talked to them. We've had animal control from Hillsborough come out, which has recognized poor living conditions for the animals in question, and a flea infestation, which came over to our lawn. The cats have been using our lawn as a litter box, and we have 2 pit bull mixes, or not pit bull, I'm sorry, bulldog mixes that will eat the feces, and they get sick. And one is allergic to flea bites, so we have to, it becomes a problem. Our backyard is fenced in 100% with a 6-foot fence, and we can't let our dogs out in the backyard to enjoy themselves without supervision. As recent as yesterday morning, I saw the black and white cat on my lawn again, and Tom Baroni has told me to take photos of the cats on the lawn. The house, I don't know how the tenants can live in it because you can smell it from the street. And you can smell it from my front doorstep.
So it is occupied,
It is occupied.
and the cats, as far as you know, belong to the occupant?
Yes, we went through this. Yeah,
Okay.
they are not feral cats that are being fed.
And they're being fed. That was my
Yeah.
my first question was going to be, are they being fed?
Yes,
Obviously, they're hanging around, so.
yes.
Got it.
They are hanging around. Now, I know that there has been a noticeable act by the tenants to keep the cats inside. They've all gone inside now, but they're still coming out or getting out and getting onto our lawn.
All right, any other questions?
They also get out at night and they fight on the lawn.
Right.
And the dogs get up and bark, and then we're up all night. So,
Okay.
any questions?
Sir, can you just verify that these photos are the ones that you sent me?
Yes.
'Cause I didn't take these photos.
No, he did not take these photos. These are absolutely from my camera. And these two were the ones that reopened the case. These are the two that were on our lawn after Tom had come over. So we've gone to Hillsborough County, we've gone to Tom, it's escalated to this. We don't want any problems, we just want, our dogs to be happy.
I have another question. The response from Hillsborough County was,
Basically, he came and he tried to enforce the tenant to take care of the animals and not leave food out. And he said that basically, if they're on our lawn, we can trap them, bring them to him, and then he'll neuter or fix them, and then bring them right back to the, and then we are charged to rent his cage. So he said it doesn't do anything.
this is Hillsborough County Animal Control?
Yes,
Yes.
yes.
Thank
He
you.
said that they spay or neuter them and bring them right back to the place where you got them from.
Thank you.
Yeah.
There being no other questions. Tom, do you have another?
Unless somebody else wants to. That's no problem.
Hi there.
Thank you, council, for taking the time.
Name and
My name
address,
is-
please.
My name is Melissa Newbert, and I am a homeowner at 204 Woodbine Avenue, across the street from the cat owners. Lived there for 20 years. It's only been in the recent 2-3 years that we've had issues with these cats. I am a dog owner. I own an elderly dachshund who, like dogs, will get into cat feces. Those cats are in our yard. And last year, I've dealt with 2 bacterial infections with my dachshund that the vet has related to cat feces. I have no cats. I keep my dog under control. I keep my dog leashed. It's never outside my yard without me there. Their cats run rampant in our yard. They come in our yard, they take care of their business. They're in my backyard where I have a bird feeder and bird bath, and I'm reluctant to put feed in the bird feeder anymore because the cats are back there stalking the birds. Their yard, their house does smell like cat feces. I've been reluctant to walk by it many a time and walking my dog because the smell is very bad. And there's been a number of times, there's just been kitty litter stacked up in the driveway, just bags of it for garbage pickup. It's a beautiful street. It's just sad to see it going downhill with those type of people living on the street. So, yeah, we do have a cat problem there, and it was up to 6 cats at one time. I apologize, I don't have any pictures. I have contacted Mr. Borelli's office, and I did file a written complaint months ago when the cats were getting out of control. I did contact Hillsborough County. They advised me that at the cost of $5 a night, I could rent a cage. I would have to go pick up the cage. I would have to catch the cat. I would have to take the cage out to Falkenberg. They would spay the cat and try to put it up for adoption for 30 days. If it was not adopted, they would bring it back, or I would have to go get the cat and bring it back and let it loose again. So I don't think that would solve the problem.
If it's spayed or neutered, it would help the situation, but it won't help it immediately.
It won't help, it would probably reduce the population, but the cats would still be running free without any control or tags or leash or what have you.
So they're increasing just with kittens and more kittens? And-
Yes, and they are being fed. The cats are laying out there in the driveway, and ironically, other cats have come into the neighborhood, and my fear is now it's a coyote attractor, which of course signs are being posted in the area because of the coyotes. So I am out there in the evening walking my dog, fearing that factor as well.
Okay. Any other questions?
A question from Mr. Barone.
Thank you.
Yes, sir.
We've now had, excuse me, now had two witnesses testifying to the upkeep or lack thereof of the home itself. Has the health department got involved in this at all, or has it risen to that level,
It
or?
hasn't risen to that level.
Okay,
Usually, when the first time it's presented to the board, something like this will give the benefit of the doubt to the tenants
Mhm.
to clean up the area, but it hasn't not risen to that.
and there's no other violations other than this particular cat issue?
Not at this time. There is another violation that I'm going to address afterwards.
Okay,
It's just an in-off vehicle that's stored in the carport. I will be addressing that,
Okay.
but outside that, everything else, they got a permit for the roof shingles. Everything else is taken care of.
and you've had conversations with the tenant,
Yes,
and they know what it would take to correct the issue?
yes.
Okay, thank you.
Yep. And the tenants are here.
Okay.
I would like to talk.
I'm sorry.
Hello, my name is Jim Williams. I live at 210 Woodbine. I've lived there for about 14 years, and first time I've ever been here. And obviously, there's a lot of different things that have happened, but the cats have been an ongoing problem. I guess it was 3-4 months ago. The cats were as much as like 6 or 7 outside, but you could tell that there's a bunch of kittens inside as well. The shades were torn down from in the front, and they had been like that for months. When this was all fixed before, everything seemed good for about 4 to 5 weeks, and then it just totally fell apart again. We also have a dog that we take for a walk. I won't let the dog go anywhere near that. I had to change my leash so that way they have to walk right next to me, because otherwise they eat the dog poop as well, or they eat the cat poop. I mean, it's just really disgusting. That the house has such a horrid smell, especially at night, that it literally makes you sick walking by. So, like, it's hard to just walk by the location. The issue that I also have is I have a fenced-in backyard. We try to let the dog go out back, but yet we can't do that because our dog likes to roll in the cat poop. So then we have to, do that, give the dog a bath every day, and that's obviously not good. Lately, I've only seen a couple of different cats. I do believe that they're quiet. I don't have any other issues with them. I think they try to keep them inside, but there seems to be a lot, and it's still a massive issue. It almost seems like they're throwing the cat litter out the window. That's how bad it smells. So, but I just wanted to say my piece.
Thank you. Is there any other one, any other neighbor that's wishing to speak on this case?
Randy Newbert, 204 Woodbine. I am Melissa's husband. And just to kind of reinforce what she had to say, what I see is happening now is the cats are being corralled during the day, and then at night they're being let loose. As referenced in the last speaker, the windows at one point had shades that were torn down, and you could see in the house and see kittens up on the couch. What they did was they put a reflective window screen or window shade that went right on the window. You can no longer look in that house. And what that's done is that stopped from the visual effect of seeing these cats on their couch and kind of hiding the problem that has been hid during the daytime, because the cats are now inside more so at daytime and let out at night. The problem progressively got unacceptable. As a lifelong resident of Temple Terrace, my father built this house in 1955, and I am now living in the house my father built. I have seen this city change in many ways, but what's hardest for me to accept is when somebody rents a home, comes into our neighborhood, and then degrades it the way they degrade it, by not having the smarts to upkeep the yard, the smell, The cats, we have to keep our dog on a leash. We have to keep our dog at bay. And these cats get to run loose and do whatever in the heck they want to do, when they want to do it, where they want to do it, with nobody in control of these animals. And it's been a lousy situation for the people like us that are having to live around this rental home. Realistically, we have 2 rentals on our street. One's a lot worse than the other, and the worst one is this one we're talking about. And that's where we're at. Cats are corralled during the day right now, the way I see it, and they're out at night. Before, they were out all the time, excuse me.
Okay,
Thank you.
thank you. Tom? Before we have the owners or the tenant, in the code, there's a certain number of animals that you can, there's a limited number of animals that you can have. Is that correct?
Not that I'm aware of.
Okay.
Not in this code.
Okay. All right. I thought there used to be a number of somewhere around,
I think if you're a licensed breeder,
yeah.
it may be a different, maybe something to look at, but the number of cats, it's very hard to police that. I'm just gonna,
Yes.
I'm just gonna tell you that.
Yeah, they come in batches.
Okay.
Okay.
Can I ask
Sure.
You said you had some discussions with the owner,
The tenant
But
and
not-
the representative from Invitation Homes.
and what did that person say?
They said that they would send a representative over there to speak to the tenant.
This was recently, or,
That was probably about a month and a half ago.
but you don't know if they've actually
Don't know the
contacted?
dialogue, no.
Okay, thanks.
Okay.
Thank you.
Tenants?
Tenants. Name and address, please.
Hi, my name is Caroline Ektuvaprani. I live at 207 Woodbine Avenue.
I'm the husband. My name is Watis Ektuaprani. I live in the 8403 Delray Court, Apartment 2, Tampa, Florida, 33617. I'm retired military. I just got out of service, trying to get my second degree. But I came back because I was retired because of my certain condition, and part of it is the reason why I have to live separately with my wife, and doing so because it is temporarily. Just because this is my hometown is in Orlando. I'm here trying to get a second degree so that I can get a job, so that I can be the quality individual again. And the
Let me address this first.
the thing is, we have to live separately, so she
Yeah, but
she cannot take care of a lot of
Stop
things in the
this.
house.
Let me speak, please. Okay?
Now, I'm trying to help her take care of everything as much as I can. The cats, she have a couple of feral cat that ear clipped, and it was she was working with the Hillsborough County Pest Control and
No, animal.
animal
So,
control.
let me
So-
speak because I can explain it a little bit better. So I work for the Rebel Rescue, and I work for the Rebel Rescue. I foster cats, and we do pick cats up from wherever, most of the time from the high kill shelters. And I used to have a lot of cats, and I had 4 of them outside, and there were like 2 of them with clipped ears that I was feeding and taking care of as well. When the neighbors complained about this, like the first neighbor said he lived there a couple of years, and he never complained until just recently, last August is when they start, talking to me about that. I put in my cats. I already transferred the ones that I had fostered, and I only have my cats that I keep which are those 2 cats, and I have a dog as well. And flea infestation. Fleas are in Florida everywhere. That's a problem we have here. All my cats are on flea medication. The Rebel Rescue pays for that. All my cats are neutered, spayed, microchipped. I have a tag from the Hillsborough County Animal Control. They came twice to my house to check everything, all the animals, all the tags, everything is in order, vaccinations and so on. The pictures, the neighbors complaining that they see cats running around. Why don't they have pictures right now of the cats running around? Because the cats are not running around anymore. I put them inside. I have one cat which has a clipped ear. That's the black and white cat. He's half feral. He destroyed my door, and many times when I open the door, he dashes out. And sometimes it takes me a while to catch him, because at first, I can catch him, but he gets smarter. He realizes that I keep catching him. And that is the only time when he gets out is when he runs out. And I cannot always prevent that. I don't just let him out and say, oh, go ahead, pee or poop on the neighbor's lawn. That is not my intention. And the neighbors, my next door neighbor to my right-hand side, probably 208, they have a white cat. That cat is outside 24/7. None of the neighbors complained at any point of time that this cat is outside. I have pictures on my cell phone because the cat is next door, so it hangs out on my lawn, on my car, across the street, everywhere. But nobody has a problem with that cat. So it's not really a problem that it's cats outside, it's a problem that it's my cat outside. That's how I see it, although I already have my cats inside.
Do you feed outside?
Not anymore. I used to feed because there were some feral cats that came around and I was feeding them.
About when did you stop feeding them outside?
When I had the violation in August,
Okay.
yes. And then I spoke, I guess, to him? I think you called me, right? Yeah, so I spoke to him and he told me not to feed anybody, and I don't feed the cats outside anymore. And yes, I do have litter outside sometimes, especially during the trash days, and yes, it smells, it's litter. There's not much I can do to prevent litter from smelling, unfortunately, yeah.
Any questions?
I just had one clarifying point. You said you had 2 cats and 1 dog currently?
Yes.
That's
Mhm.
it?
Yes,
And
that's my, yeah.
The other claim was that there were 8, which is...
6 or 8,
Yeah.
12?
No, and I had the invitation homes that I rent with. They came, they checked. The police came. I had animal control twice to come to check. You all are welcome to come and check. I just want this to be over because they just say 12 cats, 6 cats, 8 cats, how many cats? That's why animal control came to my home twice to check.
Mr. Snow?
Yeah, just so, but you said you are animal rescue, so you do have cats coming and going, so there's times when you could have
Yes,
more than
in the
2.
past, I don't do
But-
this
oh, you don't do
anymore
it
because
anymore.
of the neighbors complaining. So I put them all into the house. I talked to the Rebel Rescue and I told them that I have to move to another foster homes. So the foster cats that I had, they were moved. They already all moved.
So currently you only have 2 cats.
My cats, yes.
And from what
Yes.
you said, only one of them actually escapes outside?
Yes, I got him when I moved to Temple Terrace. He came over. He was a feral cat. I got him fixed, got his ear clipped, and he was outside. And I was feeding him with my cats that were outside, my foster cats. When the neighbors complained, I put him into the house too. But he does sometimes gets out because it's hard to contain him and he runs out.
So there's no way to put him in another room or someplace where you could?
That's what I'm doing, but he destroyed my door. That's
Oh.
the problem. Every time I put him into another, room, the door is wooden, and he kind of scratched it and broke it. Yeah, that's the problem that I have.
Large cage, maybe? I don't know.
Yeah, I have a cage now, and I'm trying to get him to stay in it, but he meows a lot. So the neighbor's probably gonna complain that he meows. So it's a little bit difficult to, find a solution for him. And I'm trying to get him, housed to somebody else, but because of him being half feral, it's really hard to find somebody to take him in, unfortunately. So I kind of stuck with him until opportunity arises to rehouse him, rehome him.
Okay, thank you.
Yeah, and this is for Mr. Barone, if you wouldn't mind. I realize that cases like these are extremely difficult to police.
Yes.
You said you've had a discussion with them. If we were to find them in violation and give them 30 days to come into compliance, is that something that you can be sure of after 30 days? Or,
You have to use a lot of discretion here.
yeah,
I think that, given the tenants 30 days, I think that's the way to go. We'll monitor, I monitor this property every day I go by.
okay,
But it's not a daytime problem, it seems to be a nighttime problem. So if the neighbors can update me with photos or a phone call, we'll go from there, you know? But I did not bring an affidavit of compliance with me based on everybody's testimony. I'm not willing to submit an affidavit of compliance.
okay,
So, okay?
thank you.
Mr. Chair, I actually have a few kind of procedural questions here, if I may. And this might be for Mr. Barone or Ms. Shoshone. This case is against Sway 2014-1 Borrower LLC.
Right.
Is that the property owner?
That's the property owner.
So if there's a finding made, it'll be against that property owner,
That's exactly
not
right.
against the tenants. And Ms. Garcia, I did not hear, did you indicate whether or not we had proper notice against Sway 2014-1 Borrower LLC, where we'd be going against an absent respondent?
We did.
All right.
We did have proper service.
Thank you.
Thank you, sir.
He seems like to have a lot to say, so.
Okay.
I would like to say one last thing.
Name and address.
Christopher Kreitz, 211 Woodbine. When I initially complained to the tenant, I walked up to her house, knocked on her door, waited about 15 minutes after several knocks. There were over 5 cats standing around me, just sitting there. She finally came out, and I said, "We have a cat problem. You know, how can we resolve this?" Trying to be a good neighbor. She looked at me and she said, "These aren't my cats." I'm like, "What do you mean? None of these cats sitting here are yours every day for a year?" And she said, "No, they're not mine." And I'm like, "Come on." And she said, "Oh, well, I foster some." And I'm telling you right now, she's doing the same thing. That's what really ticked me off, is she looked at me straight and lied. There is a cat problem. You had 3 people on the street. I have pictures, and I have new pictures. She said I didn't have any new pictures. I will produce pictures if you need some. But they are still getting out.
Okay. Has there been any change since what she stated August?
Yes, and I stated that earlier. She has seen, and the other tenant, or the other residents that own houses on the street have stated. She has moved them inside. But I would also like to say that we looked her up at previous places, she's had problems with cats. So if you believe her and think that this is going to stop, she has a compassion for cats. She wants to help cats. I don't doubt that. And that might be a good and admirable thing, but she can't have them running all over our neighborhood. You know what I mean?
I agree. I understand.
Yeah. So.
I'm going to ask her a question. Carolyn, when you, if I may ask, Carolyn Wilkins, when you're fostering these as a good foster parent, are you having them neutered and spayed?
Absolutely. All the cats get neutered and spayed. And about the neighbor, what he just said, that I lived in various places and I had complaints everywhere. I would like him to show that proof that is straight lying. It's not in the internet because it never happened. We lived in Ruskin before, and my husband retired there. And then we moved to Tampa, and then we moved to Temple Terrace. And the reason for that is because my daughter goes to the King High School IB program, so I moved close by so she can be closer to the school. You can look up the internet. You have my last name, my first name. Please look it up. If you find anything where I had problems with cats, neighbors, or any other things, please let me know. I'm not aware of that.
How many cats do you have this evening?
I have 2 cats and I have a dog. That's my animals. And the neighbor, he came to my door the first time. I looked him straight in the eyes. Where do you want me to look? On the ground, on the ceiling? I didn't know what's going on. I was a little bit taken aback. And when he asked me about the cats, I never said those cats are not mine. I told him those are my foster cats, and some of them are not all cats are mine that he gonna see around. There are some cats that live around in Temple Terrace that I used to feed that would just come to eat. That was in August. Since I don't feed them, I haven't seen any other feral cats that come around.
So you haven't fed them since August?
No, I have not fed those cats.
Rich, can I ask a question?
Yes.
You said you
Mr. Buckley.
you own 2 cats and 1 dog.
And 1 dog.
How many cats, excluding those 2, are you currently fostering at your home that you may not consider yours?
Oh, I don't foster them. I moved them
Only
out.
cats on your property right now,
My-
at your home right now, are 2
Those,
cats and
yes,
1 dog?
those are my cats, yes. And the fosters, I rehomed them to another foster home
Right.
with the
Yeah,
rebels.
that's what you said earlier. I just wanted
Yes.
to be sure that you weren't,
Okay.
Any other questions? Are you good?
Yes, I just, again, just wanted to make sure the board procedurally understood that this case is against the property owner, which is the Sway 2014-1 Bauer LLC. So if there is a finding made, the finding will be against the property owner.
Any other questions? There being none? Thank you.
Okay. Would you like me to email all the information in regards to the vaccination, neutered, spayed? My cats
Not,
or do
that
you-
we're hearing tonight what we're,
Okay.
the case tonight, and we're going to have discussions, have a motion, and have a vote. And that's our extent
Mhm.
of this evening's
Okay.
responsibility. If you would want to have that information ready, should Mr. Barone, Director Barone, have to go out again, well, he will be going out again to verify. So if you feel that it's important to do that for him, you can do what you wish.
Okay. All right. Thank you.
All right, thank you all. I call for a motion.
I'll make the motion.
David?
Thank you. In case number 19-4612, City versus Sway 2014-1 Borough LLC, I move that the city has proven by a greater weight of the evidence the following violations of the City of Temple Terrace City Code exist on the property located at 207 Woodbine Avenue. Violation of Section 6-33 subsection A, animal running at large. This motion is based on the sworn testimony this board has received from the code enforcement officer, as well as several witnesses, along with other evidence, including photos, affidavits, police reports, and the notice of violation, all of which is received and entered as part of the record of this hearing. I further move that said violation be corrected on or before December 11, 2019. If the respondent does not comply with this order on or before that day, they are ordered to pay a fine for each and every day the violation continues past the date set for compliance. Upon consideration of the following factors: the gravity of the violation, any action taken by the violator to correct the violation, and any previous violations committed by the violator, I move that the fine be $50 per day up until the time that it's corrected.
Is- A second by Mr. Blah. Any discussion?
I have a question about how do we quantify compliance in this case? Because it's a tough thing to quantify. Like if your grass is too high, you know it's too high. If a cat gets out once, you know, I think it's a tough job to police. I think in this case, it's a matter of just excess. We all have cats. I have 4 because I'm married to a cat person. But it just sounds like it's gone over what is reasonable and affecting many people's lives. So that's just all I wanted to say on that.
Okay.
I think if we heard earlier from Mr. Barone that he felt that he could determine whether or not the violation had been cured within the next 30 days. If, as she says, there's only 2 cats there, I'm sure he'll come back with a notice of compliance at the next meeting. If it's not, if it's still an ongoing problem, as we've had, I think, 5 witnesses come up and tell us tonight, then that's a different story. So I think, I agree with you that these particular types of cases are always extremely difficult to police and to determine whether or not compliance has occurred. But I have complete faith in our code enforcement board, and they have stated that they do believe that they can determine whether or not compliance is achieved.
Okay, any other discussion? There being none, call for a vote. All in favor?
Aye.
Aye. Opposed, nay? No nays. Okay, for you neighbors and for you cat owners, lovers, and as many people are here in Temple Terrace, what we have found is a guilty verdict for the violation that you were charged with. And there's a $50 fine if you go beyond the compliance deadline of December 11th. If you start harboring cats again, or fostering cats, as you call it, then the problem will continue. However, if you can make a concerted effort, I would guess, to keep your cats in and also remain in compliance through, then the fine will not begin to accrue. So it's all in your hands with compliance at this point. Okay?
Questions? With the problem here, I just wonder, does the dog allowed to be off leash in
No.
the neighborhood?
No.
If the dog there's not leash approach me, can I kill him? Because it might be threatened.
That's pretty extreme. Would you want to have your
I
cats
know, but
killed?
you don't know, because I saw some dogs ran up to me, right, with some old lady walking behind, barking at me, and I was,
Yeah,
service, any certain noise, I do really get
Yeah,
uptight.
I understand.
So-
But your statement is after the fact and it's irrelevant to the
I
case.
know, oh, I'm just asking, council member,
Okay.
I just asking, that can I do something to defend myself in that case?
That's not my,
No?
that's
Oh, I'm
not
just
my
asking.
purview.
Sorry,
I can't
that's
tell
it.
you.
Thank you.
All right? The case has been heard. So, we're done.
Thank you.
Thank you.
You got here for the fourth quarter, it's fine.
Mr. Chair, since we've had our latest member of the board and we're waiting, why don't I go ahead and go through the ex partes
Please,
with him?
please.
All right. I'd like to ask if you've had any ex parte communications regarding any of the matters that'll be coming before the board this evening. If there's been any verbal communications, if you'd please disclose the sum and substance of those communications, when and where those communications occurred and with whom they occurred. And if you've had any written communications, if you'd please disclose the sum and substance of those communications, and then please provide a copy to the city clerk to be made part of the record.
I have none.
The next case,
Okay,
case number 195586, City versus Amir S. Khan and Sabahat J. Khan and Fix It by Johnson Tree Company, LLC, for the property located at 12103 Brightwater Boulevard. The case is before the board based on alleged violation of Section 828A1, permits application required, and Section 12768A1, tree unlawful removal. The case will be prosecuted this evening by City Attorney Pam Shishon. City has evidence that the notice of violation and notice of hearing were properly served.
And Mr. Chair, I'll have a few things to say about this, for the board on this case before we get started.
okay, go ahead.
All right. Tonight, there's going to be an additional consideration when you deliberate or render a decision on this matter. There is a state statute that may prohibit a finding of a violation, and that is Section 163.045. Do all of you have a copy of that?
I'll
Does
be
that
handing it
begin?
out shortly.
If we could hand it out to them now, I'd appreciate it. I'd like for them to review it before we start the hearing.
Thank you.
And if you would, pay particular attention to paragraph 1. Has everybody had a chance to read it over? All right. Now, the city and the respondents will be, through their attorneys and through the witnesses, will be presenting facts regarding this case. So when they've finished presenting their cases, their facts, and in this matter, I would also ask you, with procedure-wise, before any motion is made, that you do close the public hearing and deliberate, because you will be taking into account whether or not the facts in this case may bring Section 163.05 into play, and whether the facts show that a finding would be prohibited, or conversely, whether the facts show that this board can move forward with any type of finding. All right? And finally, the last thing I'd like to say is I want to remind this board that your decision must be based on the evidence that is presented here today and nothing outside of this hearing. All right? Thank you.
2 questions before we begin, Mr. Chairman.
To our attorney,
To-
board attorney?
Or the board
Yes.
attorney. One, do we know the date that this particular chapter was enacted?
Mike?
The question is the date that this took effect. This was very recent, I believe July 1st?
It was in the summer, I think.
It was July 1st. It's in the statutory. I think I'm being recorded. I apologize. It is July 1st, 2019 is when it took effect.
And my second question is, in paragraph 2, there's words that say may not require. Does that mean it's optional, or does that mean the same as cannot, in your opinion?
In my opinion, it is cannot.
Okay. Thank you.
In this matter, the city is going to present its case a bit more formally than we normally do, since We have more than the usual number of witnesses and exhibits. And so with your permission, I would like to offer a brief opening statement.
Please.
In this case, the city issued 2 notices of violation of our tree removal regulations. Notice was issued to the residential property owners, Mr. and Mrs. Khan, and to the company that was hired to remove a tree on their property, Fix It by Johnson Tree Company, LLC. Mr. Khan and Daryl Johnson are being represented by Mr. Crawford, their attorney, who is seated here. And I will provide each of you with a copy of the city's ordinance that was cited, including the related sections of that ordinance. A certified copy has been provided to the clerk for the record, and the section of the ordinance that we tend to prove was violated is section 12-768A. I'm going to go ahead and pass that out.
Thank you.
Thank you.
And pursuant to section 12-768A, no protected tree shall be removed without first obtaining a permit from the city. Our evidence will show that a grand live oak tree was being removed on the Khan's property until the city issued a stop work order. We anticipate that the defendants will assert that a newly enacted Florida statute, section 163.045, preempts the application of the city's ordinance and prevents the city from requiring a permit in this case. The city would then establish that the new statute did not apply under the facts of this case and that a permit to remove this oak was required. You've also been provided already with a copy of that Florida statute for your reference later if needed. I also wanted to mention that the notices of violation that were issued also reference section 8-28A of our city code. We are not proceeding with a violation of that particular ordinance, so you can ignore that one this evening. We are only dealing with the sections that I've handed out. And I yield the podium to Mr. Crawford if he wishes to also make an opening.
Mr. Chairman, I would prefer to make my opening when we present our case. I thought the way this proceeded was the city made their case, and then we presented our case after that. If you want to hear me open now, it's up to you. I'll be happy to do it whichever way you want. It makes more sense to me to do it all together in my case, is the only reason I say that.
Well, I would like to hear you do it, because we got a lot of stuff going on, a lot of papers to read, so we want to know what, in order for us to evaluate the information that we have,
Sure.
we want to hear how you're going to present.
I would be happy to.
Thank you.
I'll be brief. The city attorney has correctly laid out the situation that's before you tonight. It is an unusual situation for a code enforcement board to be in, usually you argue over the facts. The car does have a license. The cats aren't mine, whatever those happen to be. Today, we're not saying we did not cut the tree. We are not saying we got a city permit. We're saying that because of the operation of 163.045, we are not required to do so. I will present a little bit of case law that talks about how to interpret statutes, how judges, which unfortunately you guys are sitting here as tonight, interpret statutes. And I'm going to assert that this is in fact one of the simplest, most plain written statutes I've ever read. The Affordable Care Act is 1,600 pages. The IRS tax code is 6,000 pages. They were able to put this law into about 5 lines. I believe it's plain and simple on its face. I understand completely why the city is frustrated, and let's even say has a beef. Whether the legislature overstepped what they should do or not do is not up to me, and it's not even up to us tonight. But it's our position that if the city wishes to do something about the statute, which between the League of Cities and the Florida Association of Counties, I can't imagine that they don't have the political power to try, that is the correct remedy for this. There's not a judicial remedy to change the statute or to not apply the statute because it's unpopular. And I'll present a little bit of case law regarding that. And to me, the city has in evidence the documentation by the certified arborist that was provided to the owner under the statute. My argument is going to be that once the certified arborist provides a letter to a residential owner saying that a tree is a danger to person or property, that's right out of that section 1 of the statute, then that's the end of the case. There really isn't any further argument over whether the arborist is right, whether the letter had errors in it, whether the city arborist disagrees, whether 20 arborists disagree. Under the statute, it just simply doesn't matter. That's the end of the argument. Now, I'm going to go further and present a factual case that this tree was a danger to persons and property. I have the property owner, I have the arborist who wrote the letter, and the company owner that cut the tree. And we're going to have all of them come up and talk about the tree and show that in a practical consideration, the tree was damaging the property in a considerable way. It was dangerous. He applied for a permit 2 years ago to the city and was denied, and he felt like he didn't have any choice than to go and ask an arborist if it was a danger or not. I'm honestly, as a lawyer, I almost argue against myself on even presenting that evidence because I don't think the case has to go there. I think under the statute, it's clear. You get an arborist letter certified to the owner saying that the tree is a danger to person or property. The city has no further involvement at that point. If the city doesn't like it, the city certainly can complain to the ISA, the International Society of Arborists, and say, this didn't meet your standards, this is a wild guy arborist out there who's not doing what he's supposed to do, rein him in or take his license away. Or you can go to the legislature and change the law, and I believe those are the only two options that the city has. And that's where we stand.
Okay,
Be happy to try to answer any questions now or later.
it'll be later.
Thank you very much.
Thank you.
City's ready to call its first witness.
Please.
Mr. Amir Anisi. Not sure how we're going to do this because we don't have a witness stand, but I'll kind of stand over here. So.
Name and address.
Sure. Amir Anisi, building official, City of Temple Terrace.
Sorry,
Amir Anisi, building official, City of Temple Terrace.
Mr. Anisi, how long have you been the building official for the city of Temple Terrace?
Since 2016.
And briefly, what are your duties as the building official?
Reviewing construction plan, issuing a permit, inspections, all the construction activity, and Florida Building Code services.
Excuse me. Amir, could you come a little closer to the
Sure.
mic? Thank you.
And do you hold any licenses or certifications from the state of Florida related to your job?
Yes, I do. I'm a certified building official by the state of Florida.
And have you ever held any other positions with the city of Temple Terrace?
Prior to becoming a building official, I was building inspector, plan examiner with the city.
And you can look, so that they
Sure.
can hear you. You
Sure.
don't have to look at me to answer
Sure.
the question. Look at the board.
Sure.
So, I'd like to now direct your attention to October 3rd of 2019. and ask you whether in the course of your employment, were you on North Brightwaters Boulevard that day?
Yes, I have been. I had a scheduled inspection next door to the subject property, and I was scheduled to do my inspections.
And while you were on the property doing your inspection, did you notice anything that was occurring on the subject property?
Yes, as I was pulling into the property, I saw crane. I saw few individuals moving trees, debris. I see a bobcat, somebody riding a bobcat, and I heard chainsaw the other side of the fence, and appeared to be somebody's cutting grand oak trees.
And are you able to what is a grand oak tree?
As I said, based on the land development code, they have certain diameter, I think more than 24 inches. DBH considered to be a grand oak tree.
And when you said the subject property, are you referring to 12103 North Brightwaters Boulevard?
Yes, ma'am.
And once you saw these things happening on the property, did you go over there?
No, I didn't go to subject property. Still, I was on the property. I was scheduled to do the inspections because all the crew, they were next door, and I didn't go, to the subject property. I was at the inspection location. I was scheduled to.
At any time, did you speak to anyone on the subject property?
Yes, as I was finishing my inspection and pretty much wrapping up leaving the property, I reached out to the gentleman and asked his name, and he says, "My name is Daryl Johnson," and I asked for required permit for this tree, and he basically took his phone out and opened up, pretty much his phone and showed me a letter in his phone. He says, "This is my permit." So.
First, I'm going to show you what's been marked for identification as City's Exhibit Number 1, and I'm going to show you this and ask you, I've already provided a copy to Mr. Crawford, and ask you whether you can identify what is in that picture. And that's just a yes or no question at this point.
Yes.
Okay. And is what you saw on the subject property on October 3rd depicted in that picture?
Yes, that's exact the picture.
Okay. And I'm going to move to it.
Mrs. Sean, may I ask a technical question? Is the board able to see that picture on their screen as he's looking at it?
No, I'm going to give them a copy in a moment.
Okay.
If it gets admitted.
Okay,
Okay. So right now, no.
I got you.
So at this time, I'd like to move Exhibit Number 1 into evidence. You can keep that.
Without objection, the evidence will be admitted into the record.
Just give them the top picture. Yeah, if it's there. So now, Mr. Anisi, were you able to see any part of this from the property next door when you went to do your inspection?
Yes, pretty much whatever was above the fence, 6-foot fence between the two properties, yes.
And does Exhibit Number 1 accurately reflect what you saw on the subject property when you spoke to Mr. Johnson?
Yes, as I said, pretty much whatever was above the fence section, not the lower portion of the trees, because I didn't go to next door property. Yes.
How did you make contact with Mr. Johnson if you didn't go to the property next door?
He was next door. He was running the bobcat next door, pretty much removing the larger limbs as they were cutting. and coming down off of the trees. He was running the Bobcat. He was,
So the Bobcat was on the other side of the fence
yes,
from the Khan's property
yes.
and operating it over the fence?
Yes, the only thing was operating over the fence was a crane, and also people were using the chainsaw.
Okay. Now, you said that you asked him about a permit. What did he say?
He says he has the proper permit, and I asked him if he is able to show it to me. He, again, reached out to his phone, and he just pretty much showed me a letter in his phone. He says this has been issued, as a permit.
And did you take any time to glance through that or read that?
No, I haven't, and what I did, immediately I reached out to city arborist over the phone, via phone, and I asked him to get involved, because again, that's outside my expertise and my responsibility. I had other commitment that day that I had to move on, so I reached out to city arborist.
Would you know a city permit if you saw one?
Yes,
Okay. So what he showed you on the phone did not look like a city permit?
it's just simply a letter being written by individual.
And then what did you do after you looked at his phone? Who did you call?
I called city arborist Joe Ferris, and I told him that a tree is being cutting down at the subject property, and I asked him immediately to get, in his car and come over and, find out more details and more understanding about the situation.
And did you have any more interaction with Mr. Johnson that afternoon?
No, I mean, pretty much I wrap up the conversation. I left it to the city arborist to talk to Mr. Johnson.
Did you ever speak to Mr. Khan that day?
No, I haven't.
Okay. I have no further questions of this witness, but I'd like to reserve the right to recall Mr. Anisi for rebuttal.
Mr. Sean, may I ask one question?
Sure.
Yeah, thank you. It's just a very quick one. This photo, number one, the evidence that was introduced, did you take that photo?
No, I have not.
Who did, do you know?
To my knowledge, city arborist took that photo.
Okay, thank you.
City would call its next witness, Joseph Ferris. So, would you please state your name and your place of employment?
Joe Ferris, City Arborist, Temple Terrace.
And how long have you been employed by the city of Temple Terrace?
Since February of 2017.
And your title is what?
City Arborist.
Do you hold any licenses or certifications from the state of Florida or any professional organization related to your work for the city?
Certified Arborist through the ISA.
Now, is the ISA a state organization or a professional organization?
Professional, international organization.
And do you hold any degrees related to your work?
Degree in landscape architecture.
And I'm going to direct your attention to October 3rd of 2019 and ask whether in the course of your employment you were on North Brightwaters Boulevard that day.
I was.
And what address did you go to?
I don't recall that.
I'll have to give you-
Yeah, sorry, I was 12,
Let's see.
0301. I'm sorry.
Was it 12103
Yes,
North Brightwaters
Yes.
Boulevard?
yes.
Okay. And why did you go there?
I had received a phone call from Amir Anisi regarding a large tree that was being removed. I had questioned if I had approved of that and asked me to come out and take a look at it to determine what was going on.
And what did you find when you arrived?
That most of the tree was down. There was maybe about 8-10 feet of large oak that had been removed on the side of the house.
I'm going to show you what's been admitted into evidence as Exhibit Number 1, and ask whether you took that photo?
I did. I took that afternoon.
And does that photo accurately represent what you saw on the property when you arrived?
It does.
All right, and so once you arrived at the subject property, what did you do?
Talked to Daryl Johnson, asked what was going on, if he had a permit. He explained he had a permit that had been approved by a certified arborist by the name of Nicholas. And I said if he had a copy of that, and he could show me, because there was nothing in our system that showed a permit had been issued, and that we do not have a Nicholas on staff as a certified arborist for the city. So he brought up on his phone documentation that he said was the permit for the removal.
And did it look like any type of a permit?
No, it didn't.
I'm going to show you what's been marked as the city's exhibit number 2 for identification, and ask you whether you recognize that.
I do.
Okay, and what is that?
This was the documentation that he had on his phone that he had said was a permit issued by or approved by the certified arborist.
Now, is the contents of that piece of paper what you saw on the phone?
No. No.
Okay. When did he hand you a piece of paper?
No, I asked if he could email me a copy of this, so we sent it to my work email address.
And did you print that out at some point?
What I did after that, I went ahead and took a few more pictures of the debris and everything that was going on. Went back to my car, opened up the email to be sure it was in there before I came back to the office. As I opened up, I started reading through it and realized that the tree that had been removed in this photo is not what was on the documentation.
Well, is Exhibit 2 then what it was he emailed you?
Yes.
Okay. Move to admit Exhibit 2 into evidence.
Without objection, the evidence will be admitted into the record.
When you reviewed the document that had been emailed to you by Mr. Johnson, did it describe the tree that was being removed by Mr. Johnson on the subject property?
It did not.
What type of tree was being removed on Mr. and Mrs. Khan's property?
A live oak.
And what type of tree was declared a danger in the document shown to you by Mr. Johnson?
According to the second paragraph, it was a laurel oak.
And as a certified arborist yourself, is it difficult for you to distinguish between a live oak and a laurel oak?
No.
Where on the property was the live oak that was being removed?
The live oak was on the side of the property, which would have been the south side.
And what was the location of the dangerous laurel oak described in the document given to you by Mr. Johnson?
And a couple of locations, or a couple of spots on the document, it describes it being in the rear property.
And what was the diameter of the tree that was being removed?
I measured 36 inches.
And what was the diameter of the tree as described in the document that was shown to you by Mr. Johnson?
28 inches.
The city's ordinance 12.768 speaks to protected trees and grand trees. Which trees are protected trees?
We have approved tree list. Any of those trees on that list that are over 12 inches in diameter on private property are considered protected.
And does our ordinance define what a grand tree is?
It does. Any tree that is over 24 inches at DBH, which is diameter at breast height, is considered a grand tree.
And I'm going to show you what has been marked for identification as city's exhibit number 3. And do you recognize that particular photo?
This is the picture of the tree prior to being removed.
And had you seen this particular photo before?
Not until that particular day.
And did you take that photo?
I did not.
How did you where did you get that photo from?
This came from Daryl Johnson. When I spoke to him about the letter, he had informed me that a certified arborist for the letter, and that he had sent him a series of photos. I asked if he had anything that showed what the tree looked like prior to being removed. He did, so he texted that to my phone.
Did you examine the remains of the live oak tree that was being cut?
I did on the property next to it, just to the south, the debris of the limbs that were laying there, and then what was out in the road. I had taken some photographs of that as well.
Had you ever examined this particular tree before this day?
I had, back in, I believe it was October of 2017, November, right around in there. At that time, I was in training with our previous arborist, Dana Carver. We had been called out to the site to look at some other trees. The homeowner asked us to take a look at this tree, so we had reviewed the conditions of the tree at that time.
And did you find anything that would cause you to determine that the tree was unhealthy at that time?
Not at that time, no.
When you looked at the tree on October the 3rd, did you find any evidence that it was unhealthy?
No.
Did the letter or the document that was provided to you by Mr. Johnson indicate that there was anything unhealthy about the tree?
It describes many numerous issues with the tree, but more what you would find in a laurel oak, not in what this tree was, being a live oak. So the conditions that were described in that letter were not present in this tree that was removed.
Did you find anything within the document that was provided to you by Mr. Johnson that he referred to as his permit that would give you any indication that it was talking about the same tree that was being cut by Mr. Johnson?
I did not.
Did you ever speak with the arborist, Mr. Quilling, whose name is at the bottom of the document?
I did later that afternoon after I got back to my office. I called to discuss this.
Did you ever ask him about the discrepancies in the document?
I did. Several times I asked, trying to understand the document and what tree was taken down, because there's many discrepancies, and I pressed several times about whether we were talking about the same tree, because the location wasn't right, the species wasn't right, the size, all the issues that were listed in there weren't right. So I asked several times if this was the right tree or not.
And did he offer any explanation?
After pressing several times, it became clear, made it clear that he hadn't visited the site to look at the tree. The pictures he evaluated it was evaluated based on the pictures that were sent to him by Daryl Johnson. So there was no actual site visit to determine the conditions that were listed in this tree.
I have no questions.
I have I think just one.
Okay.
And by the way, I did a very poor job of identifying myself before, which is both bad protocol for a hearing and it's just impolite, and I apologize. My name is Jimmy Crawford. I am a land use attorney out of Claremont, Florida, for 24 years, and I do represent both the owner and Fix It by Johnson, the tree service in this case. And I apologize for not getting that out earlier. Sorry. Is there a 28-inch laurel oak in the backyard of this house?
There wasn't one that when we went back there that I saw that had the same conditions as this one.
Right, so these errors or discrepancies in the letter don't seem to apply to another tree that's on that property?
Not that I've found.
Okay, that's all I have.
Other question. Are there laurel oaks existing in the city of Temple Terrace?
Yes,
Are there laurel oaks existing in cities throughout the state of Florida?
yes.
I have no further questions. I would like to reserve the recalling, though, of Mr. Ferris.
Thank you.
City will call its next witness, Tom Baroni.
My name is Tom Baroni, B as in boy, O-R-R-O-N-I.
And Mr. Baroni, for the record, where are you employed?
I'm with the City of Temple Terrace. I'm the code director.
And how long have you been the code director with the City of Temple Terrace?
Just over 2 years.
And did you have any other position with the city prior to being the code director?
Yes, I was a zone inspector, a code inspector for 10 years.
Do you hold any licenses or certifications from the state of Florida related to your job?
No, ma'am.
And have you had any training or specific education that permits you to serve as a code inspector for the city?
I have level 1 training, it's FACE level 1 training through the Florida.
Now, how is it that you became involved in this particular matter concerning the property at 12103 North Brightwaters Boulevard?
Approximately 3 o'clock in the afternoon on October 3rd, I received an email from Joe Ferris, not just to me, to several people, stating the situation that was going on at Brightwater.
And were you the person who issued the notice of violation to Mr. Khan and to Mr. Johnson?
Yes, ma'am.
And in this particular case, I know you're used to discussing situations that you've observed, but in this particular case, was your notice of violation based on your personal observations?
Yes, on October 4th, that next day, I took a drive out to Brightwater just to observe the tree condition.
And did you make any determination yourself as to whether a permit had been pulled, or did you get that information from Mr. Ferris?
I got that information from Mr. Ferris.
And did you have any personal dealings with this particular property other than, is there an echo?
A little bit.
Other than what you have already described today?
No, ma'am.
At any time, at the time that you issued your notices of violation, did you discuss with Mr. Khan the situation?
Prior to the,
Or at the time that you issued the notice of violation?
no. The notice was given to his son.
Okay. And at the time that you issued the notice of violation to Mr. Johnson, did you discuss the situation with him?
I emailed the notice of violation to Mr. Johnson. In return, he called me and stated that he was just waiting for that to arrive.
And did you and he discuss anything about the particular, the violation or the actions that he had taken?
Yes, he stated to me that he did not read the letter from the arborist that was given to him. He did not read it.
Did you then point out to him that there were discrepancies in the letter with regard to the type of tree that was declared a danger and the one he was cutting?
I don't believe so.
I have no further questions of this witness. No, you wait up here.
I don't have anything, thank you.
Okay, sir.
Other than asking or making a motion to move our Exhibit 3 into evidence, that would conclude the city's witnesses in this case.
Without objection, the evidence will be admitted into the record. Mr. Crawford?
Thank you very much, Mr. Chairman, members of the Code Enforcement Board. I have a point of question, and I might need Ms. Garcia's help, because how to present evidence and show you guys things, I was told to bring a thumb drive, and we would put them on the computer. So I did not bring 7 or 8 copies of each of my individual photos. So I'm wondering if we can view those as we go through them, if that's technically possible.
Yes, as long as you're stating which one
I will.
you're talking about, I will look through and select it.
Okay, I'll try to
And
be
if you
very
have
succinct.
one hard copy, that could be passed out to the board.
I do. I have 1 hard copy of everything. Yes. Okay.
Mr. Crawford, I would just suggest too, as Ms. Shoshone did, ask, that it be admitted so that we can go through that process.
I certainly will. Like I say, not having been here before, I viewed 3, I think, of your code enforcement meetings, and I know that pursuant to your own adopted rules, the rules of evidence don't apply as they would in a court. It's the evidence that a reasonable person could use to find one way or another on that. And I have some of the same photos and some additional ones, and I will move each as we go through and try to get Ms. Garcia to bring them up. First, though, I'm going to make this first part brief because we haven't had much argument about the statute. I think, and in talking to Ms. Shoshone before, I don't think we're in vast disagreement over the application of the statute. I believe this case, from the city's point of view, centers on the fact that there were errors in the report such that the city doesn't even believe the arborist reviewed the right tree. So I'm going to try to concentrate on that. I would just note, I'm going to put 3 cases into the record. They're not really evidence, and I feel weird arguing case law in front of the Code Enforcement Board, so maybe these are almost more for your legal advisor as well. But as I noted, Section 163045 is quite simple. The first one is literally 3 lines. A local government may not require a notice, application, approval, permit, fee, or mitigation for the pruning, trimming, or removal of a tree on residential property. And here comes the if the property owner obtains documentation from an arborist certified by the International Society of Arboriculture or a Florida licensed landscape architect that the tree presents a danger to persons or property. The Florida Supreme Court and the Florida courts have opined in hundreds of cases on how to review and interpret statutes. But this is very simple. I had about 8 cases that I would have used in court to try to make this point. I whittled them down to 3, and I'm going to keep them very short. There's a case called Holly v. Auld, A-U-L-D. It's 450 S.O. 2nd 217. It's the Supreme Court of Florida. And they stated that courts are without power to construe an unambiguous statute in a way which would extend, modify, or limit its express terms or its reasonable and obvious implications. They went on to say, it is not a court's duty or prerogative to modify or shade clearly expressed legislative intent in order to uphold policy favored by the court. In other words, the court may have to swallow hard and choke it down because they don't like the law so bad, but it's not the court's duty or prerogative to modify or shade that if the legislative intent is expressed clearly. That's a case we have here. I drove around your city this afternoon, and I know that it's a Tree City, USA, and I see the amazing trees, and I completely understand the want to protect those trees. So I say all of these statutory preemption arguments with the utmost respect for the city's position and for this board. I don't mean any of it to say I even think it's a good idea. I'm just saying that I believe it to be the law. The 11th Circuit Court of Appeals for the United States courts, which is our governing court of appeals from this area, took a case from the South Florida District called CBS Inc. v. Primetime 24 Joint Venture, which is reported at 58 USPQ second 1257. And they just added a little bit, and they talked plainly about what a legislature goes through when it adopts statutes and what a court can do in reviewing that. And they said, when words of a statute are unambiguous, judicial inquiry is complete. Court must presume that Congress said what it meant and meant what it said. And then lastly, just one little nuance on that, the Florida Supreme Court said again in Dadeland Depot v. St. Paul Fire and Marine Insurance Company, 945 SO 2nd 1216, for the record. This is on page 8. It must be assumed that the legislature knows the plain and ordinary meaning of words used in statutes and that it intended the plain and obvious meaning of the words used. In this case, I don't think we have any ambiguous words. We did talk about may, because that is a question that comes up a lot of times, and I would certainly agree that both times it's used in subparagraph 1 and 2, it has the same effect as shall not, may not. And there is a lot of legislative statutory interpretation on that. I didn't bring anything specific on that. We could certainly research it further if it becomes an issue before this board. But the legislature certainly knows how to make exceptions. For example, if the city is supposed to review an arborist report and determine if they find it sufficient, they could have said that the owner has to get the arborist report and submit it to the city for review. They didn't say that. They could have said that if the city disagrees or another arborist disagrees, that you have to go for a permit or some sort of dispute resolution. They didn't say that. They know how to say all of that. They do it in other statutes all the time. They did know how to accept things because they accepted mangroves. Section 3 says the section does not apply to the exercise of specifically delegated authority for mangrove protection. So they knew how to limit the law. Instead, they made it very explicitly. An owner obtains documentation, which, by the way, Mr. Ferris, when we were talking about whether it was a permit or not, and I apologize, Mr. Johnson is not an attorney and certainly didn't know whether, and I'll get him to talk about this, whether it's a permit, whether it's an authorization, how the statute works, that goes. So when he said he had a permit, he legally misspoke. He had documentation, which is exactly the word that Mr. Ferris used twice when he was referring to the letter, documentation from the certified arborist. So the legislature knew how to write the statute. They wrote it simply and plainly, and under the CBS primetime case we just cited, I'll quote it, "Court must presume that the legislature said what it meant and meant what it said." So that's all the legal argument you get from me, except perhaps in a slight conclusion at the end. And let's get on to the factual issues that are before you as well. With that, I would like to call Mr. Amir Khan. And what I'm going to do the same. This is a bit awkward, but we'll, please state your, can
Name
I
and
tell if
address.
I'm being recorded all right? I want to make sure. I don't know.
Name and address.
Amir Khan,
Okay, thank you.
Amir Khan, 12103 Brightwater Boulevard, Temple Terrace, Florida,
Yeah.
33617. Amir Khan, 12103 Brightwater Boulevard, Temple Terrace, 33617.
Mr. Khan, you are the homeowner in question of the lot that the tree was removed upon?
Yes.
Okay. Give me a brief history of your purchasing of the house and then the tree issues since then.
I purchased a house a little bit over 2 years ago, and we have a nonstop issue with that tree going with the sewer lines getting clogged up. And every few months, I need to get a sewer guy to come in and snake the lines. Spoke to the city, they said, you cannot cut this tree. You gotta live with it. It's okay, I'll live with it. For 2 years, I'll live with it. Then I would talk to one tree guy, say, you know what, that there's a law passed that you got a right to cut the tree down. That gentleman was charging me about $3,000. Then I saw Mr. Darrell Johnson working for the city of Temple Terrace as a contractor, cutting the trees down on my street. He said, you know what? And Mr. Darrell Johnson, I made a contract for $4,200 to cut this tree down. And I put down the contract, everything needs to be done with the legal permit, whatever requires, needs to be taken care. I'm not a tree guy, I don't know the contracts, and nothing else. It says on my contract, and you probably have a copy of that. So the law was being passed, he went ahead and he cut it, and I have a crack about over 1/2 inches on my walls. I'm not gonna lose $1 million property if the city arborist is having a problem with me to cut the tree down, for whatever reason, or I have to demolish the house, or I have to cut the tree down. Or every few months, I got 2 special need kids to get a guy to come and snake the lines. At 3 o'clock in the morning, I put an alarm over there. If the lines backs up, alarm goes off, we shut off everything. This is ridiculous. What am I doing here? Why, I shouldn't be standing here. They should be standing over here to explain it to me why I have to suffer in $1 million property.
Okay, let's go through some of these exhibits. Ms. Garcia, I want to pull up the photos, if you don't mind. And I know you're doing double duty, and I'm
And for
sorry.
2 years, I did not touch it. I love it. So I did everything by the law, by the contract, everything straight.
You just pull them up in order from top, bottom, and I'll adjust accordingly. No, that's, move along, that's
It's the
not.
front of the house.
Okay. Okay. Mr. Khan, did you take this photo?
Yes, I did.
What is it of?
It's a snake with all the roots lining my toilet lines.
So you had a plumbing backup in your house?
Unlimited times. I live with this thing.
Okay, but this was one time you had a plumbing
Yes,
backup.
so I just
You
took it.
called a roto-rooter or a plumber?
I'm in the property management business, so I have a guys out there, so he come out and snakes a line for me, because it's cheaper every time. I cannot spend $200-300 every time for the guys to come out.
And, what does that picture show? It's not terribly clear.
It shows
up
my
on the-
front lawn, it shows the extension cords that he has to run to connect the snake to it, and you see the snake with the roots in it.
The snake is the coiled wire or metal?
That's correct, that's correct.
All right, and in the middle, those masses are
Yes,
roots and all?
that's
And does this plumbing line go near the tree in question?
The plumbing line, that's amazing, it goes in front of my house, in the middle of my house, in one of my bedrooms, right underneath my bedroom, that's where the line is. And the tree roots are so big enough that they're reaching and they're just crushing the lines.
Okay.
And what I gotta do, crack the slab, put up a new lines, break the house, I don't have any options.
Okay. I would like to offer this as Respondent Exhibit 1.
No objection.
Without objection, the evidence will be
Sorry,
admitted into the record.
thank you. All right, let's move to the next, Ms. Garcia. Nope. Yeah. Keep going down to the first one, that one, right there. Okay. Mr. Khan, did you take this picture?
Yes, I did.
What is it of?
I got a 4-foot wall right next to my house, attached to my house. I got a crack over 1/2 inch big. I don't need a certified architectural engineer to tell me I got a problem. If these arborists cannot figure this thing out, then I don't know how they got licenses.
So is there a root from the tree that is at the bottom of this?
Yes, which is pushing the wall up and the wall is cracking.
Okay. I would like to offer this as defendant or respondent exhibit 2.
I'm going to object to this one on the grounds that you can't tell where the crack is. I don't know if that's a sidewalk, if it's part of the house, if it's a decorative wall. I have no idea what that picture is of, so I will object because it
Okay.
does not offer the board any way to consider it.
It does, of course, because I have the person who took the picture here who is subject to cross-examination by the city attorney and questions from the board as well.
I still object. I don't think the person saying they took the picture is going to help. We need something in context. Is there another picture that shows this in context of the house?
The city arborist knows that too, and I mean, they've already seen it.
The photo or the damage?
The damage, I've showed it to them.
Okay. the formal rules of evidence do not apply here. It isn't the same as a court. If this is evidence that the board feels it can take in context with the testimony offered as to the where the picture is and what it evaluates, the board can either use it for what it feels like or dismiss it because they don't feel we proved it.
Might be able to help. Is the crack on a wall in this picture our exhibit number 1?
Is perhaps, let's talk about it. I'm
I'm
not
just-
the one who can answer that.
Well, I'm not. I'm asking, maybe your witness can say.
Then on cross-examination, you can ask him that, or would you like me to ask him? I'll do it either
I
way.
think that we can move forward with your picture if you'll ask him now.
I'd be happy to. We're looking at Exhibit 1. I don't know if you guys have it in front of you, but Mr. Khan, can you tell me where that crack is on this?
You will see the crack right here.
Okay. Oh, it is there. So it is in the retaining wall. Is the retaining wall attached to the house?
Yes.
Okay. Let me
And
see.
the next step is my foundation.
Okay. I understand. Here, this is your copy back.
Thank you.
Thank you. Okay. Okay. All right, I'm going to do two more. This was your Exhibit 3?
Yes.
Okay. Just very briefly, I'm looking at the city's Exhibit 3, which is the photo of the tree before it was cut. Mr. Khan, did you take that picture?
I don't remember.
Okay, all right. I think it may have been Mr. Johnson, then we'll move on from that. All right. So, you hired Mr. Johnson to obtain an arborist report to see if it could be taken down under the new law that allowed it if a certified arborist reported it as a danger. Is that correct?
Yes, I did. I spoke to Mr. Johnson when he was working for the city as a contractor. Said, I got an issue with this tree, and it's been 2 years I'm requesting City of Temple Terrace to cut this tree down, and it's a nonstop headache for me. Something would be done. He said, yeah, the new law is passed, and we could cut this tree down without problems. So then I made a contract with him, saying, whatever necessary, if it's legally doable, do it.
Okay. I don't have any further questions.
I do. Mr. Khan, did Mr. Quilling send you a copy of his report here that's marked as, or that's been admitted as city's exhibit number 2?
Yes, I've got this email, yes.
Okay, and who did you get that from?
Mr. Darrell Johnson, he
From
forwarded it to
Mr.
me.
Johnson? Okay. And when did Mr. Johnson send that to you before he cut the tree?
That's correct.
And did you read that before he cut the tree?
I'm not going to read or understand a legal contract of Laurel or this, assuming he knows what he's doing, he's a licensed contractor.
Well, this is supposed to be the opinion from the arborist that the tree was
As an
injured.
attorney, yes, you could say that, but as a homeowner or a regular guy, I don't know these things. I hired a licensed and insured contractor to do a job which is working as a contractor for City of Temple Terrace. So if City of Temple Terrace is hiring a contract, then he must know what is he doing.
So, Mr. Khan, if you had read this, would you think you would have noticed that it was talking about a tree that isn't the tree on the side of your house?
Ma'am, when it says laurel oak, live oak, I don't know those things, but front and back, yes.
Okay, you do know front and back, the difference between that?
I just told you that.
Okay, and you know the difference between 28 inches and, say, 30
No, ma'am, I
inches?
did not go and measure
40
it.
inches?
I did not measure it.
All right.
I mean, why would I measure it?
And in 2017, did the city's arborist tell you to hire a structural engineer to determine what was causing the crack in the wall?
Not at that time. Later on, Mr. Joe Farris have told me to hire a licensed structural engineer, but I don't need a structural engineer. I got to cracks this in my walls. My sewer lines are getting clogged. Why would I need to spend money on a structural engineer to satisfy those things? That doesn't make sense to me.
To determine which tree or what may have been causing the
This is a
cracks?
tree right next to the foundation, right next to my plumbing, and right next to the wall. It's the common sense.
Are there other trees also in the yard?
The other trees are further away, ma'am, much
And-
further away,
and-
almost about close to 30 feet away.
Okay, and have you measured the root system in any of those other trees?
The root system goes with the canopy of the tree. That's as much I know. and those canopies are not coming where this location underneath my house is. The tree which is next to my house, which is causing a problem, is going on top of my house where all the problems are.
So it's your opinion that a tree root cannot extend past its canopy?
Arborists would tell you, but this is, as a common person, I'm assuming, yes.
Okay. You don't have any training as an arborist?
No, ma'am.
And you don't have any training as a landscape architect, do you?
Thank God, no.
Now, this wall that you're showing the picture of the crack, City's Exhibit number 1, and I'm gonna show you that. That wall isn't actually attached to your house, is it?
It is attached to the side of the house, yes.
Isn't there a space between the wall and the house?
Well, the space is with the crack, that space it is, but this wall is attached to the
Okay.
house.
And that wall is not retaining anything, is it? It's a decorative wall.
You could say that, yes.
Okay. So it's not a structural part of your house. If the wall didn't exist, your house would be fine, correct?
Well, I'm not gonna wait till my whole house demolished for you to make that decision. I'm sorry, that's not the way to go.
So in order to keep this decorative wall from cracking any further, you decided that it was necessary to cut down a grand oak
So what you're
tree.
telling me is to
I'm
not.
asking the question.
And I'm answering that question.
Was it necessary to cut down a whole grand oak tree because of a crack in a decorative wall?
Would you live to special needs kids
It's-
and a sewer line backing
I'm
up?
asking you
I'm
a
telling
que-
you the answer, you want to listen
I'm
to my
asking
answer,
you
I'm
about the
telling you.
wall. Is it necessary to cut down the whole tree?
It's not about just that wall, you gotta look at the full picture. Please don't twist things around, you gotta look at the full picture and be reasonable with that.
You're talking about snaking pipes?
Sewer line.
Lines? Sewer lines, okay. And what expert told you that it was this tree that was causing the problem with your sewer lines?
I'm sure one of the arborists will come up and explain it to you with the sewer line and this thing, that will make sense to you.
Is there any expert here that
There is no
looked at
other
your
tree, there's no other tree right next to my property which is causing this issue. The other trees, I just explained it to you, are about 30 to 40 feet away from this line. So there is no other ifs and buts, this is the only tree that is causing it. We don't need to twist things around. And I'm being told just pay $7,500 and this whole thing goes away. So if you care about trees, then you should care about trees. Now it's not a matter of $7,500.
I'm gonna show you a picture that I'm gonna identify as City's Exhibit number 4 and ask you whether you see the tree that was cut in this picture.
Yes, ma'am,
Okay.
over there.
And that's the one that's outlined in red?
That's correct.
Okay. And then I'm gonna ask you, is there another tree that's also in the front of your house?
Yes, ma'am, that's further away.
Okay. But there, you have another large tree right in
That is
front of
about
your
close to
house.
30 to 40 feet away. That's all, I'm keep telling you that.
Okay. So you talked about the tree, you're saying that it was inside your pipes?
Tree is not inside the pipes, the roots.
Okay, the roots were inside your pipes?
Yes, ma'am.
Okay. And so did you hire someone to simply cut the roots that were growing near the pipes?
My dear, when you cut the roots, you cannot cut the roots because they're gonna keep come back. You go cut in the pipe. This problem is underneath my slab. You cannot cut the slab to go underneath to do this thing.
Did you hire someone who gave you that opinion?
I'm doing real estate for about 22 years. I got multiple properties in Hillsborough County, City of Tampa, multi-million-dollar operations. I do this thing every day. I know common sense. Please,
And how much work have you ever done to cut the roots growing near foundations?
what do you mean by that?
Have you ever done any work cutting roots growing near foundations to protect a property?
I don't cut roots. That's not
Okay.
my job.
And you didn't hire anybody to assess the roots that were growing near your pipes?
When the gentleman comes out to snake the lines, they cut the roots inside the pipe, not outside the pipe. When you cut it inside the pipe, they go back right into it.
Did you ever consider cutting them back from the pipe?
How you gonna cut the whole slab to go underneath the slab and go do it? How you do it?
I don't know, I'm not an
Ask
expert,
your
are
experts
you?
then. I, common
Are
sense.
you an expert?
Common sense, my dear.
Are you an expert at cutting tree roots?
Are you an expert?
I'm going to object. This is just argumentative. He hasn't held himself out as an expert in anything.
I had a professional licensed contractors, and I'm standing here and explaining.
Just trying to get an answer to the question, yes or no.
I already explained it to you.
Okay. I have no further questions.
I don't have anything, Mr. Khan. Thank you very much. Yeah. Respondent would like to call Daryl Johnson. Mr. Johnson, would you give your name and address for the record?
Yes, Daryl Johnson, 14045 21st Street, Dade City, Florida.
And do you own a company called Fix It by Johnson?
Yes, I do.
How did you become involved in this case, or your company become involved in this case?
I was trimming out there on Brightwater, and Mr. Khan had approached me and told me that he'd like to get the tree
Oh,
removed.
I'm sorry, yeah, you
Yes.
gotta talk to me there.
Okay,
My-
thank you,
my
sir.
bad.
Thank you, Tom. I was trimming on Brightwater, and Mr. Khan had approached me and told me he had had questions and concerns about a tree next to his home.
And what did you tell him you would do in a process about that?
Well, he had explained to me that he had someone else that could do it on 1159, and I told him I also
You
had
mean
a...
House Bill 1159 that became Section 163.045 Florida statutes?
Yes.
Okay.
And I explained to him that I could have an arborist evaluate this tree. And as I was looking at the tree, it was common sense to see that the damage it was causing. And I know that they just spoke on the root system. Didn't go to the school on the arborist, but I've seen a lot of trees in my time with the damage at lifting up sidewalks, foundations. And I'm gonna say 50% of that root system, as big as the tree is going up under the foundation of that home.
Okay, then let's lay a little foundation for that. Sorry, no pun intended.
Right.
You're not a certified arborist, is that correct?
No, I'm not.
How long have you been in the tree business?
Since I was 13, off and on. I was introduced to
Then I
this
gotta
business
ask you how old
20,
you are. You
25
shouldn't
years.
have done it that way.
I'm 53.
Okay. So that's roughly 40 years.
Yes.
Do you have any education specialized in that, or has it just all been experience?
Just experience.
How long have you owned your own company doing it?
This is my fourth business, this name here in the tree service business.
So how many years have you been in business, in the tree service business?
25.
Okay. And have you had an opportunity to deal with a lot of trees whose root systems are causing problems, either through pipes and sewer systems or foundations?
Yes, I have.
And is it your experience that they can cause significant damage in a situation such as this tree was in?
Yes.
Okay. So then you contacted an arborist to come make a determination on the tree, is that correct?
Yes, I did.
Who and when and what happened?
Nick Quilling is who I contacted. I used him in the past month before I had him evaluate this tree here. And this was the second time using Nick, and
So you asked him to come out and evaluate the tree?
yes, I did.
Did you ask him to predetermine or to determine that the tree was a danger?
Yes, I did.
Let me rephrase the question.
Okay.
Did you ask him to come out and evaluate it neutrally and just decide as an arborist if it was a danger or not?
Yes.
Okay. You didn't direct him to find that it was a danger so you could cut it?
No, I did not.
Okay. Do you know how big this tree is? How diameter breast height?
When I first looked at it, I was guessing around 35 inches.
Okay. Did the arborist write a report on the tree?
Yes, he did.
Did he deliver it to you before you cut the tree?
Yes, he did.
Did you deliver that report to Mr. Khan before you cut the tree?
Yes, I did.
Okay. That's all I have.
Mr. Johnson, were you present when Mr. Quilling came to examine the tree?
No, I was not.
So you don't know whether he actually looked at the tree physically or not?
No, I did not.
And did you read Mr. Quilling's report before you started to cut the tree?
I didn't know, I did not. I read that I knew that I had to report in my hand, but I didn't read every fine line on the report.
So how would you know whether Mr. Quilling sent you a report about some tree in Pasco County as opposed to the tree that you went and cut down on Mr. Khan's property?
I knew the address and I knew the report.
You didn't
I
know
read
whether that,
briefly.
you didn't know what that report talked about. You didn't read it.
I didn't read every fine line on that report, but I knew that it had his address attached and the tree that we discussed on it. And him being a certified arborist, that's basically what I had in my
And
email.
did you discuss a tree in the backyard of the house?
No, we did not. Until me and Joe had come out, we discussed a tree in
Did
the
you
backyard.
discuss a laurel oak tree?
Not laurel. We just talked oak tree beside the house that was causing damage.
So for all you know, he could have sent you a report that he issued on a tree somewhere else, and that you didn't have you didn't have the appropriate documentation at all.
I knew that him being a certified arborist, I trusted his decision because I just had one, like I said, done a month prior to that. And
I'm
we
not
just,
asking about his decision. I'm asking you whether, I'm saying, you didn't know whether you had the proper documentation in hand at the time you cut that tree down or not, because you didn't read it.
it wasn't a permit, it was an arborist report. Everything that he said, I based that on his decision because I had it in my email on my phone.
Okay, so according to his decision, you should have been cutting a laurel oak tree in the backyard that was only 28 inches. Right?
It was all the trees that we knew about was on the side of the house was causing damage. And that's the facts.
And you're in the business of cutting, trimming, and removing trees, right?
Yes, I am.
And if Mr. Quilling had not said that this tree was a danger, you wouldn't have had a job that day cutting that tree down, correct? That's how you make your money, getting rid of the trees.
I did it on the law in his report. It said it was dangerous and the visual common sense the first time I looked at the tree.
Saving trees, you don't make any money, right? Yes or no? You make money saving trees and not cutting them down?
I don't mind saving trees.
I have no further questions.
I have a couple of redirects, if you don't mind.
All right.
First of all, do you also trim trees and shape trees and do many things other than simply cut down trees and remove them?
Yes, I
Do you make money doing that?
Yes, I
Okay. You weren't present when the arborist evaluated the tree. How did you identify the tree to him and tell him which tree to go look at?
I sent him a photo.
You sent him a photo.
Yes.
Was it the photo that is the city's Exhibit 1 that has the tree on the side?
Yes, that
You
is
sent the
one.
arborist that photo.
Mhm.
So when he sent you a report with that address on,
Mhm.
you naturally believed that he had looked at the tree that you sent him in the photo?
Yes, correct.
Okay, I don't have anything else.
Mr. Chair,
That is-
and if I can just address something procedurally to both attorneys. We're kind of moving on, but I think the board is saving questions for the end, so just realize they may be calling witnesses back up all right? I just kind of want to make you aware of
Shaw's
that.
party, however you want to do it is fine.
All right.
And the respondent would like to call Nicholas Quilling. We've been hearing for an hour and a half about the report, so now we're going to hear the horse's mouth.
How you doing?
Name and
Name and
address.
address for the record, Mr. Quilling.
Nicholas Quilling, 10617 Schooley Gardens Drive, Thenotasassa, Florida.
And what is your job, Mr. Quilling?
I am actually a senior crew leader at Hillsborough County Public Works. I run the tree crew, tree removal, and tree trimming crew.
Okay, so you work for Hillsborough County?
Yes, sir.
Okay. And do you also have a night job as a certified arborist?
Yes, sir.
Okay. I'm going to- Do you recognize this document, Mr. Quilling?
Yes, sir.
Is it a copy of, no, it's not a copy, it's an original of your certification from the International Society of Arboriculture?
Yes, sir.
Okay.
That's correct.
And when were you certified?
Beginning of December 2014.
And are you still certified today?
Yes, sir.
Okay. I would like to offer this as
No objection.
Respondent?
Without
number
objection,
three.
this time I want you to take
Oh,
it over there,
please, okay, I'm sorry.
because we might not have a picture of it. Without objection, the evidence will be admitted into the record.
Is this the only copy of this you have?
I asked him, and he has another one.
Have to.
You're okay giving that one up?
That's the original that I was originally given by the ISA.
Would you like to get it back?
I would like to get that
Is
back.
there a way?
Are you able to make
Yeah.
a copy when you?
That would be nice.
If there's no objection to entering a copy, then I would appreciate that, so we don't have to go get another original.
That's fine.
I've had experts actually bring framed diplomas before and try to introduce them, and that's always a little awkward.
It was framed. I just took it out of the frame and in my truck.
Mr. Quilling, so since 2014, you've been a certified arborist. Estimate how many trees you have evaluated in that time.
With a full-time job and part-time job, probably thousands.
So you use your certification at your day job for Hillsborough County as well?
Yes, sir.
Okay. You were asked to evaluate a tree upon this property. Tell
sir.
me how that happened, how that came about.
I got a phone call from Daryl Johnson, Fix It by Johnson Tree Service, that he has a problematic tree at a customer's house in Temple Terrace. Would I mind going and checking on it and doing a report for it? I was like, well, as long as we could find it and deem it a danger and a high level of danger and causing damage to the property owner, personal property, I was like, sure, no problem. Gave me the address. I went over there on Brightwater, did a level 1 assessment, which is a windshield assessment. I didn't physically walk up to the tree. The gate was closed, plus he has other gates and fences. Did a level 1 assessment, basically from a distance, probably 80 foot maybe.
Okay,
Maybe 80 foot, 90 foot max. I was
Okay.
looking at the tree.
okay.
I was in the evening time after work because I get off at 3:30 from the county. So it was probably around 4:35. So, I mean, it was clear. I could see.
Okay. And what did you see when you evaluated the tree?
Oh, I seen a large oak tree on the side of Mr. Amir's house that had gnarly branch growth growing out over to the neighbor's property, and as well as gnarly branch growth growing over the top of Amir's house.
Explain what you mean by gnarly branch growth.
Gnarly branch growth would be like not a single stem with perpendicular branches coming off. Gnarly system would be a tree branch that goes up like this. A decurrent tree basically grows up and has multiple stems that go out and do this number.
And is that bad?
Yes, it could be very, very potentially a high level of danger, yes.
Why?
Because of the aspect ratio of the limb. Basically, if you get a limb that's from here to the road, and you have a inclusion to where it meets at the union of that tree, the base of the tree.
What is an inclusion?
Included bark would be basically where the tree limb grows off to the main stump, trunk of the tree, basically. So if you got a gnarly limb going way out 40, 50 feet, it's putting a lot of pressure on that union and will cause structural failure of that limb, and it will fall. And sometimes I've seen them fall and they've hang up in the tree like this, and you have to literally grab it with a machine or physically cut it out of there and then pull it off of there. That's gnarly growth system. It's just,
And this tree had limbs like that extending both over Mr. Khan's house and over the neighbor's
Yes, sir.
fence wall, whatever that is,
Sure.
on the edge?
yes, that's correct.
And did you deem those a danger to that property?
Yes, sir.
Why couldn't you then just trim those limbs? How is the whole tree still a danger?
It would be basically you'd be altering the structural stability of it. So if you cut a large limb off, the way I like to compare it to people would be if you cut your arm off compared to your finger, which one's going to heal up faster? Obviously, your finger's going to heal up faster.
I don't want either, thank
Right.
you, but that's.
It's just, it's basically I try to let the customers know, homeowners know, even some of my tree guys know, listen, it's detrimental to the tree if you cut large limbs, remove large leaders off of that tree. It's very detrimental to the tree and the overall health of it.
Okay. Your report says the tree is within about 2 feet of the foundation of the house. Is that a problem with a tree of this size?
Yes, sir.
In what way?
In my experience, starting out, I was at the county starting out, and basically we would go through and remove, as y'all know, sidewalks are a problematic issue with tree roots. Throughout Hillsborough County, throughout the state of Florida, it's multi-million dollars. They got contractors everywhere replacing sidewalk, chopping up root systems right by the trunk of the tree. So when you chop off majority of the trunk flare, it compromises the structural stability of the upright, of it standing upright.
Okay.
So that being said, when you're that close to the house and you have that large of a tree, your leaders coming off of that tree are the size of me and you put together.
The roots that come off the tree?
The trunk flare at the
Okay.
base of the tree at ground level.
Okay.
Physically, you could see the trunk flare going into the house, the bottom of the house.
You could see that.
Yes, I can see that.
And
That
so
would-
you can't just root prune those, I've seen the root saws that they bring in and try to cut that off. You couldn't just go on the edge of the foundation, cut it all along the edge of the tree and solve the problem?
It would be very detrimental to the upright structurability of the tree.
So that would make the tree even more dangerous to fall?
And it's more susceptible for insects and diseases to get inside that big cut in ground level or underground level.
So as a certified arborist, is that something you would recommend?
Not necessarily in that situation, no.
Okay. Let's go over the report. Let's look at the city's Exhibit 2. And if I could I borrow yours, or I can put it on the screen? Go ahead. Thank you very much. Okay. This was identified as the city's Exhibit 2.
Okay.
Is this a letter that you wrote regarding this tree?
Yes, sir.
Okay. And this is the letter you provided to Mr. Johnson prior to him cutting the tree?
Yes, sir.
Okay. The city's identified several issues they believe with the letter.
Right.
You described the tree as a laurel oak. The city has described the tree as a live oak. Are you certain which it is, and if so, how did that mistake happen?
I'm pretty certain it was possibility it could have been a live oak. The tree was covered in vines and covered in moss. So it was hard to tell exactly from where I was at on the first evaluation of the species of the tree.
Okay.
It was oak tree. There's 150 species of oak trees.
Do those species actually hybridize between themselves also?
Not necessarily. Sometimes they do. If they're in the same ecosystem, they will.
Okay. But from your level 1 assessment, which
Right.
we're going to talk a little bit more about in just a second, you weren't close enough to necessarily determine whether it was a laurel oak or a live oak.
Yeah, there's so many different kinds of species. It could have been an evergreen oak, could have been a live oak, it could have been a post oak, a sand oak. I mean, you could just go on and on and on.
If it's a live oak, does that change your assessment of the danger of the tree?
And that placement of it, no.
Okay.
No.
You still would have declared it a danger to the property?
Yes.
And therefore removable under the statute we're talking
Regardless
about?
of what species of tree it was. It was
Okay.
it was causing damage and is danger to the property owner.
You wrote in this report that the tree was in the rear of the property. Did you receive the photo from,
Yes.
of the tree, and it was the one that we showed?
On the right of the house, yes, sir.
Okay. Let's just get right to that. Is that the tree you evaluated,
That
the
is
one that was in the photo?
That's correct.
Okay. Why did you identify it as being to the rear of the property?
Just an honest mistake. I was in a hurry. I have a lot of stuff going on. That was after work. I was.
Okay. It was in a hurry. Does that mean you didn't do a ISI evaluation as you should as a certified professional?
Not necessarily. I was there and I was evaluating that tree from a distance and looking at it. And my professional opinion, that's the tree, and it was just an honest mistake. I put it on the back side of the house when it should have been on the right side of the house or the north side of the house, or however you want to label it, northeast, southwest.
You also stated the diameter at 28 inches.
Right.
The city believes it's 36 inches. There's actually enough we could go out and still measure it today and find out. But if you missed the diameter that much, how would that happen?
The vegetation, overgrown vegetation on the base of the tree to about 20 or 30 foot up into the middle story of the canopy. That vegetation at the trunk of that tree, those vines are this big on that tree, and they go around 3/4 of that tree. So if you was actually get a proper measurement, you'd have to cut those vines out and go straight to the bark whereas in none of those vines are cut out. So,
So all of the DBHs are estimates?
not necessarily, no. That was a somewhat estimate on my situation because of the vegetation, and I subtracted the diameter of the vegetation that was growing up that tree to calculate the approximate of 28-inch laurel oak.
Okay. Tell me about a level 1 assessment. Is that, how does the ISA standards, how do the ISA standards tell you to do tree evaluations?
Basically, the level 1 assessment was just a windshield. Basically, it's just a, you know, you look at the tree and in professional opinion, hey, this is causing damage, this is the problem. The level 2 assessment would be actually physically going up there, looking at the tree, looking at the ground, looking at the root system, the structural stability of all the limb systems. And level 3 would be basically topography, a denseness test for the actual base of the tree, for the trunk, and a little more procedure going on with the level 3. So it's just steps.
Under ISA standards, is a level 1 assessment acceptable to determine if a tree is a danger or not?
I'm not positive on that, but it's a requirement for track certification, so you can do level 1, level 2, or level 3, and
Okay.
it can be processed.
So you did a level 1, and you determined that the tree was a danger to the property from that level 1?
Yes, sir.
All right, and has anything you've heard to date changed your opinion on that?
No, sir.
Did you, okay, so after the city was involved in October 3rd and October 4th, were you called again to look at your report, or evaluate your report, or evaluate the tree again?
Yes.
What happened then?
I got on the phone with Mr. Amir, talked to him, made arrangements to meet him at his property, met him at his property, went over the situation, what was going on, took my own measurement of the tree, reevaluated it at the ground level, reassessed what was going on, talked to Amir about the problems he was having again, same situation as the first time.
Okay, so did anything in that second one, was that a level 2 evaluation?
That would be a level 2, yes.
Did anything in that level 2 evaluation change your mind about the tree being a danger to the property?
No, sir. Actually solidified it.
Okay. Did you write any other report or letter or documentation after that?
Yeah, I did an upgraded report. Basically, it's just another report without all the lingo in here stating this and that and this and that. So it was just it was a report from a level 2 assessment. This was a level 1 assessment. Level 2 assessment was a little more, I physically went out there and looked at the tree. Amir showed me, this is the problem. This is what the problem is. This tree is literally 2-3 feet from the side of this guy's house, and he has massive utilities coming in the side of this house. So it doesn't change my mind at all from level 1 or level 2.
Okay.
It actually, like I said, solidified it even more.
Do you know if that second report or letter was provided to the city?
The second one, I don't think so.
Okay. Did you ever speak to anyone at the city? Did you speak to Mr. Ferris, the city arborist?
I did. I spoke to Mr. Ferris that afternoon, I believe October 3rd or 4th or something like that in the evening.
The evening of when the city came out to...
Yeah, and shut him down.
Yeah,
And shut
okay.
Mr. Darrell down.
What was that conversation like? Did you explain to him that you wrote the report?
Yeah, he asked me if I wrote the report. I said, yes, I did write the report. He asked me if I went out there. I said, technically, I didn't go out to the tree and physically walk up to the tree and hug the tree like I usually do. I just did a level 1 assessment. He said, where's the open cavities at? I was like, they're in the tree. You can look at the tree and tell it's bad. It's a bad situation.
And after you did the level 2 assessment, is that still your opinion?
Yes, sir.
Okay. I don't have anything further. Thank you.
At 9, we wait till 9? Wait till he's...
Yeah, just sometime.
Mr. Quelling,
Yeah.
2 hours.
Same,
I agree.
I could use
Same
a break.
here.
I could use a break.
Seconded that?
We're going to finish, if he's not going to take a half an hour, we've finished with this one.
I'm not long-winded. We're good.
We're going to take a 5-minute break or 10-minute break.
Okay.
Now or after he's done?
After he's done. We don't want to interrupt progress.
Mr. Quelling, you mentioned a track certification, that track, TRAQ,
Right.
correct?
All right.
And that stands for what?
Tree risk assessment qualification.
Okay. And do you have a tree risk assessment qualification certification?
Nope, not at the time.
Do you have one now?
Nope.
And the ISA that certifies you, they have a risk assessment form with instructions, correct?
Yes.
And did you fill out a risk assessment form?
No.
Is there a difference in the sturdiness of live oaks and laurel oaks?
Yes. Yes, there is.
And live oaks are more sturdy than a laurel oak, correct?
It depends. Physically, yes, they are.
And you can tell the difference between a laurel oak and a live oak by looking at basically the tread on the bark of the trees, correct?
Yes.
So you didn't have to see the leaves that are covered with moss. You could have looked at the trunk and determined the difference of the tree.
Yeah, it's heavy vegetation on it, so you had to pull the vegetation off in order to do that. You can usually decipher between a laurel oak and live oak bark, yes.
And since you did this drive-by inspection, did you see that the tree was on the side of the house?
Yeah, it wasn't a drive-by inspection. I pulled up there and I did a windshield assessment. I got out of my truck and went to Amir's fence and standing at his fence, and I was looking at the tree. I'm like, oh yeah, that's causing damage. I've been in the game too long to know that that is not causing damage to that house.
And did you go up and see the cracks in the wall?
Not at that time, I didn't, no.
Not at the time that you issued this first report?
That's correct.
Okay. And so, two places in that report, it refers to the tree being in the backyard, correct?
Right.
Did you realize at any time that when you issued this report, that it was a matter of life and death for that tree?
Did I realize it was a matter of life and death for that tree? No, I didn't. No. I was talking to Daryl about the tree, and I knew exactly which tree he was talking about because he sent me a picture of it. I mislabeled it. I made an honest mistake and said it was on the back of the property when it should have been on the right of the property or the south of the property.
When you issued this report, are you aware that there's a Florida statute that says that a residential property owner doesn't need to get a permit as long as they have documentation from a certified arborist saying that the tree is a danger?
Yes, ma'am.
Okay, so that you, as a certified arborist, rendering this opinion, I'm gonna ask one more time, did you realize that your opinion was a matter of life and death for this tree?
My opinion. It's a professional opinion.
And that it was gonna come down if you said it was a danger?
It's going to come down eventually. It's causing damage. It's a high level of danger tree. It's causing damage to this man's property.
And you can tell that looking through the windshield.
Absolutely. I wasn't in my truck. I was out in the front yard in his fence looking at it. I wasn't looking out of my windshield. It's just a level 1 assessment. That's what they call it. It's a windshield assessment. It's basically for companies that are doing massive amounts of tree evaluations, and they just ride by and be like, oh yeah, that's bad. Oh yeah, that's bad. Oh yeah, that's bad. It's
Thank you, that's all I have.
Just very quick point of clarification. I believe we covered this somewhat on direct, but it was brought up again on cross. If this tree is a live oak, does that change your opinion as it being a danger to the property?
no.
Okay. That's because of the closeness to the property and the roots growing under the foundation?
Yeah, there's a really aggressive root system on live oaks. Yes.
Okay. The risk assessment form that the ISA has, is that required to be used by you to assess a tree?
I wasn't informed of that, and I attended a meeting for basically navigating through the new House Bill 1159 several months ago, and nowhere in there was it explained that you had to do that.
Tell me briefly about that meeting. That was an arborist meeting?
That was a ISA meeting navigating the House Bill 1159, what we're talking about now, and basically what guidelines you had to follow, what questions basically came up was, you know, I can basically remove a tree if I could deem it a hazard or a high level of danger. Sure. If you got a tree out in the middle of the field somewhere and you write a report for it, you're going to get nailed. If you got a tree 2 feet from this guy's house that has been causing damage to this guy's house and is still causing damage to this guy's house, remove it. That's all you need is a report.
So you believe your report on this tree, both the first one and the second one, are within the ISA standards?
Yes.
Okay, I don't have anything further.
Okay, we're going to take a short break.
Point of order before we take a break. I understand we've all been here a long time, but I would just ask that, I have some questions for this witness.
Certainly.
I would ask that you don't talk to him. Why we're on break. I don't want you, I just prefer that you two, I mean, you can talk, but don't talk about the case and his answers.
Okay, as a matter of courtesy, I'm happy to do that.
Yeah, we do have some questions, but we preferred to wait till
Sure.
later so that we didn't interrupt what was.
Everybody needs a drink in the bathroom, I'm with you.
And Mr. Chair, along those lines too, please, I remind the board not to talk about this case while anyone's on break.
Yes. Okay.
How about them break? Mr. Chairman, I think I did not hear evidence, and I would like to. After our discussion about them, I don't think I formally got these into evidence. And I would like to, based upon the clarification from the. I don't believe they officially did.
Because I remember you clarified and then we didn't
Yeah, yeah.
formally do it. So just ask them when
Okay.
we start up,
We-
and then they'll get it.
Okay, thank you.
Call back to order. Are we ready, Kristen? Ms. Shoshone? Are you, we left with the witness. You want to?
Yes, that was the respondent's last witness.
Okay.
I would like to move respondents, I believe it's exhibits 4 and 5 that were discussed. They were the pictures of the cracks in the walls into evidence.
Without objection, the evidence will be admitted into the record. Thank you.
If the board would like to hear a closing at the end, I have a 90-second to 180-second summation. But I do understand there will be questions of witnesses and all, and I'd like to reserve that for later.
Yeah, I think.
And that's all the respondents have.
And we have a rebuttal witness.
Okay. Do you want to rebut first or you have after? First?
Yes.
Go ahead.
The city would recall Joe Ferris. Mr. Ferris, I'm going to remind you that you are still under oath.
Okay.
So, when you had testified that you had gone to Mr. Khan's house in 2017, what did you advise him to do when you met with him?
At that time, as I said before, I was with Dana Carver, our previous arborist. I was studying for the exam and training with him. We had looked at the tree because Mr. Khan had concerns about the crack in the wall. And we did see the small crack in that non-structural type knee wall. Didn't recognize any cracks along the actual wall itself. So at that time, the suggestion was, in order for us to approve the removal of this, we requested a structural engineer who could do a report, sign and seal, that stated that this tree and its roots were actually causing issues to the foundation. Because neither myself or Dana Carver are structural engineers and can, with 100% positivity, say that this tree and those roots are causing those type of issues. Nor can we say that they're not. So typically, this is what we require.
Does a certified arborist have the qualifications to assess structural damage to a building?
I don't.
And you are a certified
I am.
arborist? From the same organization as Mr. Quilling?
Yes.
You have a little certificate like he
I
has?
do up in my office.
And does a certified arborist have qualification to assess damage to sewer pipes?
I don't.
When you met with Mr. Khan in 2017, did he ever tell you that he was having a problem with his sewer pipes?
Nothing was mentioned at that time about sewers. It was about the crack that was in that small wall.
And you heard Mr. Quilling refer to, use it as an example, a sidewalk being lifted by the roots of a tree. Is that example comparable to roots growing under a house?
In my personal opinion, common sense, I mean, again, I'm not a structural engineer, but a sidewalk and a driveway are much lighter than a house. A house, you've got a foundation, you've got a slab, and then you've got a weight of a house. In this case, you've got a two-story house. In my opinion, it would be easier, and it does happen with sidewalk and driveways, roots are going to lift that. We're talking about an entire house. This is where, again, in these kind of situations, I ask the homeowner to provide that documentation by a specialist, such as a structural engineer, who can determine that. I'm not qualified to do that.
I'm going to show you what I referred to earlier as city's exhibit number 4 for identification. And have you seen this particular photo before?
I have.
Okay. And did you draw the red line around it?
I did.
Okay. And what does the red line, what is it outlining?
It's outlining the actual tree and the majority of its canopy.
And what does the whole picture depict? What is shown in that picture?
Well, there's more than one tree in this picture. You have the tree on the side, you have the tree out front.
And did you take that picture?
I did not. This was from Google Earth, from an image from Google Earth.
And the other tree that's shown there at the front of the house, is that tree still there?
As far as I know, at the time it was, yes.
You
At
mean
the time,
October 3rd?
Yeah, October 3rd, yes.
I'm going to show this to Mr. Crawford.
Okay.
Without authentication of where it comes from, I have a hard time.
You said it came from Google Earth.
So does the whole world. I won't object. It can go in. I don't care.
City would move exhibit number 4 into evidence. And
Can we leave it, because I'm going to have a cross question about it?
sure. Do you see Mr. Khan's house in that picture?
Yes.
Okay. And from your prior testimony, you have been to Mr. Khan's property?
I have.
Okay. And do you recognize the gate that's in the picture and the wall that's in the picture?
Yeah, this is out front of, along the road.
And did all those things exist on October the 3rd?
The wall was, I'm not positive about the gate. The reason for being out there originally was wanting to do a circle driveway. And we had approved removal of a couple other trees as long as he did replacement, which he did
Are
do.
you talking about 2017?
In 2017,
Okay,
that was
I'm
a.
talking about
Oh, I'm
October
sorry.
3rd of
Okay, I'm sorry.
2019.
Yes, this gate was there. Yes,
Okay.
sorry, and the wall.
All right.
Yes, sorry.
Now, you had heard, I believe, Mr. Khan's opinion that that tree roots only grow out as far as the tree canopy does. As a certified arborist, based on your education and experience, how far can a tree's roots
Tree
grow
roots
out?
can go 3 to 4 times the size of the canopy. Used to be, the thought was that it went to the drip line, which is the edge of the canopy. Now it can go 3 to 4 times that size.
So the tree that's in front of the house,
It could have roots that intertwine with that and go out just as far.
could that be the cause of Mr. Khan's problems?
It's possible, but I'm not an expert to be able to determine where those roots in the pipes are coming from.
And when you went out to the property on October the 3rd, did you issue a stop work order?
I did.
You've heard Mr. Quilling's comments. Did what he say jive with his comments that you've testified to earlier, that he did not actually go?
He never mentioned window, the level 1 with me. Again, I had pressed over and over, are we talking about the same tree, same location? Because nothing was jiving, nothing was matching up with what was removed. And that's when he said he had based it on the pictures that he was sent. He zoomed in to the picture to determine the type of tree and the issues. Nothing was mentioned in our conversation that it was a windshield inspection or a level 1.
Now, his report, the first report, that is city's exhibit number 2, states that there were cavities in this tree. Did you physically examine this tree for cavities?
I did with what was left of that, and on the neighboring property where the crane was at, there were large limbs that had been removed. I did take photos of that. There was no cavities, large cavities. What's remaining of the tree is solid. There's no cavities within the tree itself.
I have no further questions.
Without objection, the evidence will be admitted into the record, City Exhibit number 4.
Thank you. Well, hold on to it for
Okay.
a minute if you don't
Okay,
mind.
sure, no
Thank you. So, at the time of the 2017 visit,
Mhm.
And I'm not sure I understood this, you were training another arborist who was going for certification?
No, I was in training at the time.
Okay.
I was preparing to take the exam myself.
Okay.
So it was our previous arborist, Dana
Okay.
Carver, my
I see.
predecessor.
So you were not a certified arborist at the
Not
time of
at
that
the
visit?
time, no.
When did you become a certified arborist?
In January of 2018,
Okay,
so a few months later.
okay. You testified regarding, and you called it personal opinion and common sense, that a foundation is not affected by roots the same as a driveway or a sidewalk was. You're not testifying as an expert
No.
in any way?
No.
That
That
doesn't
just-
have
that's
anything to do
totally
with
my-
ISA or anything like that?
No, nope.
Okay. On this exhibit that we just entered, we discussed a tree that is out in the front yard.
Mhm.
Can you tell how far that tree is from the house?
Well, you got a car parked in there, so I'd estimate 5, 8 feet maybe. I mean, if you got a car parked in front of that, between that and the house?
Can you tell the distance between the car and that tree?
No,
Okay, so you really can't tell the distance
No.
between the tree and the house?
no.
Okay. It- This house is, the foundation is slab on grade, correct? I mean, you don't know? Okay, that's
I have
fine.
not
We can
seen
get at that
plans.
somewhere
Yeah,
else, that's fine.
yeah, yeah.
As an ISA certified arborist,
Mhm.
you have a 36-inch live oak that's been said by both sides to be about 2 feet from the edge of the house. If this house is a slab on grade, is that a preferred or even safe condition?
No, it might not be.
Are
But it-
there foundation changes, or if you were constructing a house with a tree close, do you recommend any sort of foundation changes or modifications to accept root systems that intrude?
It depends. I'm not sure when this house was built, so I don't know what the size of this tree was at the time the house was built.
Mhm.
Yeah.
I'm not sure.
Okay.
If.
I mean, again, I don't know when the house was built and
Well, if it's
the size
thir-
of the tree
okay,
at the
let's
time
just do a little bit
that
of
it was
math.
built.
If
I
it's a
mean,
36-inch diameter tree, there would be at the most 18 inches if it was a sapling.
Now,
further.
but at
No.
the time that it was
Well, it
built?
didn't move after it was
No,
planted.
but it would have grown larger
Yeah.
if it was a smaller diameter. Say
Right.
it was
It would
only
be slightly
20
further
inches
from the
at the
house.
time it was built, maybe 20 years ago. I don't know when it was
Okay.
built. It's going to grow. It's going to get larger.
Sure.
Yes, at that.
All right, so let's do the math. If it was 20 inches, then that would be 16 inches further away from the house, if it's 36 now.
Okay.
Just doing that. Is that a desirable condition, to have a 20-inch oak 36 inches from the foundation of a house?
If it's a live oak, I would be fine with a live oak. Live oaks,
Why?
because live oaks do not have the typical condition that a laurel oak might have as far as pushing up concrete. Live oaks are a much deeper root system, go much farther down because they have that span that goes out 80 to 100 feet wide. Laurel oaks are much more narrow and much more shallow root systems.
So we had the testimony earlier that the root system, or the flare of the tree as it comes, is impacting into the edge of the house. Did you witness that, or did you not witness that, or?
There was no impact on the side of the house. The side of the house did not have cracks at the time I was out there.
Right.
The stem wall, that little knee wall, yes, it did on the outside.
Okay.
But that's not structural.
Would you be able to estimate the canopy width on that oak?
Yeah, I would say at least 60 feet out in this direction.
Okay. And it would be impacted going toward the house with its canopy by the physicality of the house being right there, right? But some of the canopy is, of course, over the house, correct?
Yes.
Okay. If the root system can go 3 to 4 times that, then you would expect the root system of that to be under the foundation of the house, significantly.
Yes.
Okay. That's all I have.
Okay.
Thank you very much.
Yep.
There are no other witnesses?
I don't have any other witnesses.
Okay. Start with some questions. I have some, but we'll see how many
Okay,
others.
all right, I guess I'll start. If we could bring Mr. Quilling up?
Sure.
Thank you. Is that better? It's on. Can you hear me? Okay. So, Mr. Quilling, again, I apologize. It is getting late, and if you've answered these already, I do apologize, but I'm just trying to clarify some things in my mind. When did you say you did this level 1 assessment? Do you remember the date?
I don't remember the date. It was probably like a week. It was the end of, September, August. It was probably end of September sometime.
Okay, so and the reason you did a level 1 versus a level 2 was what?
Homeowner wasn't home.
Nobody was home.
No.
So all you could do was just see it from the fence.
It was closed up.
And at the time, you said it was covered in a bunch of moss and vines and everything else.
Yes, sir.
Okay. So when you did your level 1, tell me how you can tell that there were visible signs of damage caused by root system to structure and neighboring structures alike. How do you know that from a level 1?
From visual, it was, I couldn't see that from the road. I was told that by the homeowner and Daryl.
Okay, so
Caused
when you did your level 1, did you just go home and write the report, or did you wait till you talked to somebody? Tell me how
No,
you...
I talked to Daryl before I wrote the report, before I even went out there.
Okay.
He told me the situation that Amir was having problems with his house and this tree.
Okay, so that statement that there is visible signs of damage caused by a root system to the structure and neighboring structures alike is not your professional opinion. It's something somebody told you.
It was something that another professional tree guy told me. He might not be certified arborist, but he's professional.
But it wasn't your opinion, it was somebody else's opinion.
Yes, correct. Yes,
Okay. Okay, then you also say visible signs of included bark are presented in the stem union. If this tree is covered in mulch, how do you know that?
It covered in moss. It was covered in moss at the very top.
Moss, I'm sorry, moss.
Yeah, it was in the canopy area, the upper story and middle story canopy area. It was a heavy moss. But as you come down the middle story of the canopy, you could see there were some inclusions on some of those gnarly branches that go out.
Okay, so you could see the bark.
Yes. Not necessarily see the whole bark. I could see where the included bark was at and where it would be at.
Okay, but not enough of the bark to tell what kind of tree it was.
Yeah, it was, no.
Okay. I mean, you also say the current growth has provided very weak structural stability at the union. How do you know that from doing a level 1 from the street?
The current growth at the union?
It says the current growth has provided very weak structural stability at the union. How do you know that?
Because the limbs go 40 feet off the trunk. So it creates a weak union where that attaches to the stem.
And what's a major inclusion?
Major inclusion, the way I like to describe it is I use my hand a lot. A good union would be a nice U shape in the tree where the tree meets the tree limb meets the actual stem of the tree. Included bark would be more like a fat inclusion on each side to where the tree limb actually grows apart from the tree and has gnarly included bark right there, which basically it's not a structurally sound union right there.
Okay. And you could see that even though it was covered in vines.
I could see a couple of them, yes, sir.
Okay.
Yes, sir.
Then you go on to say that numerous open cavities are visible along main leaders, providing adequate room for moisture for insects and diseases to grow.
Yes, sir.
How do you see that if it's covered in moss?
Just dark holes on the stem. I've been just experience level to where the natural decay of the tree limbs, whenever they fall down, there's a natural decay going on inside that, and it creates an open cavity.
Okay, and then you say major health and safety issues are a result of roots damaging the septic and utility lines.
Yes, sir.
How did you see that from doing a level 1 inspection?
How did I see that they were damaging the septic?
Yeah.
I didn't physically see it. I was told that it was causing damage.
That piece is not your professional opinion. That's something somebody else told you.
That was another professional.
And then you say septic issues have been caused by roots penetrating through and damaging structural integrity of the septic system. Is that your opinion or is that somebody else's?
That was my opinion.
Based on?
Based on what I was told, that it's causing damage, obviously, to the utilities and the septic, so. that
Okay,
was-
so you
that was-
came to that conclusion because somebody else told you it was happening?
Somebody else told me that they were, had the plumbers out there several times to remove roots in the septic system. So it would be a professional contractor told the homeowner told the professional tree contractor told the ISA certified arborist, this is what's happening, this is why this tree needs to go, this is the damage it's causing.
Then you say that basically the tree's been placed improperly. What does that mean?
Proper placement of the tree. I mean, that tree would be great if it was out in the middle of 40 acres, but right there beside the guy's house, or they built the house right beside the tree.
But wasn't the tree there first?
I'm assuming it was.
So is it more like improper placement of the house?
Probably would be. And proper foundation.
Okay, okay.
Yeah.
All right. Then you say, low vigor throughout the tree has provided evidence of weak transpiration of nutrients throughout the tree. How do you determine that from doing a level 1 inspection?
Weak transpiration would be basically not getting all the full nutrients to the top of the tree from the root system.
I understand what it means, but how do you determine that by doing a sidewalk inspection?
You could look at the canopy and tell if there's dieback on it, tell if there's major limb foliage damage, weak vigor.
And you said that there's nothing in the law or any training you got that requires you to fill out any kind of official form, and that this particular undated report letter is enough in your opinion?
It's more than enough, actually.
Okay,
Yes, sir.
thank you. That's all I have, thank you.
Okay, I have just a couple of questions. There were statements made earlier throughout the evening about that you did not visit the site. It was stated, and the letter says that on September 28th, that you met with the mayor.
Yes, sir.
And at the property, and your statement was a windshield inspection, and
Right.
you didn't talk to Amir.
Level
You
one.
went and stood by a fence, but you didn't talk to Amir. See,
I associated with him on the phone through contact phone.
that's not the
But
same.
I didn't physically meet him at the address that day.
But that's not the same. It sort of just kind of throws this whole thing that you may or may not have visited the site. I'm not going to go there, but it's not you have a certification, and your presentation has a lot of ambiguities in it.
Right.
Holes, you might say, the size, the type of the tree. I'm sorry, but it as a professional, I would expect a little more completeness.
Okay.
The other thing is that I don't know whether it was you or Mr. Johnson that said something about track certification.
Yeah. Tree risk assessment qualification.
Oh, it's what, okay. All right. Track doesn't mean anything to me,
Right.
so,
It's basically abbreviations for.
yeah. I understand
Okay.
it's just, and also it was kind of, the pictures showed that this big crack in the wall is about probably 3/4 to an inch wide, and it was said the wall. Well, it isn't the wall, it's the retaining wall. You hadn't stated that, but it's been stated all over the place tonight. And I just want to verify with you that it was the retaining wall. You did mention it a short time ago.
Yes, sir.
Yes, thank you. Any, Mr. Plott?
You stated that you went and did a re-inspection,
Yes, sir.
and at what time did you do that?
It was the evening time after I got off work, 4:30-ish, 5, somewhere around there.
On what date? How long ago,
I
how
don't-
long from the original inspection to the re-inspection did you have?
Probably from the time when they shut them down from removing the tree, it was probably a week, maybe a week.
Okay, so
if
it was
that.
after they shut them down?
Yeah, wasn't long. It was probably after a week, and that's when I met with Amir at his house.
All right. And do we have a copy of that re-inspection?
The second one?
Yes.
Yeah, I believe so.
Can we see that?
I'm not here to put that in.
Yeah.
I do have it and was going to put it in, and the city attorney told me she was going to object, so I didn't.
Oh, I see.
But-
Okay.
But I'm happy to enter it or to just put it up for discussion purposes.
No, my curiosity has to do with, at the point that he was asked to do the reinspection, was it prior to any type of arrangement with the city, or, was it after the fact that the violation had already occurred, or was it before the violation had
Right.
occurred? And I think that satisfies my
Yeah.
curiosity.
Just
Thank you.
just for clarification, the tree was already cut when you went out there the second time, right?
What, I'm sorry?
The tree was already mostly cut down when you went out there the second time?
Yes, there was 12,
It was
13-foot
gone, right?
stub sticking
Yeah,
up.
okay.
Yes, sir. It's still there.
Yeah, okay.
Question?
That's for Mr. Ferris.
Sorry, no, I'm sorry, I didn't see you.
Okay.
So I thank everybody for being here so long. And my one clarification that I'd really like is, and what disturbs me, is the description of the tree on the property, whether it's a laurel oak, the size and the location. Is there any other tree on that property that it could be? Is there a laurel, or is there a live oak or a laurel oak in the back of the property, approximately 28 inches in diameter? What I'm basically saying, can you tell me with 100% certainty that that's the only tree on that property it could have been by your assessment?
That's the only one.
So there's no other, there's not a laurel oak in the back of the property that's 28 inches in diameter?
I'm not aware of, no.
Okay. I don't know if I can ask if anybody else knows if there's a tree of that size?
Well, there's a
There was
tree
the
in the
Google-
front.
The Google.
Yeah, the Google
didn't
map,
get to
yeah.
see that.
It's
Yeah.
coming, it's coming.
And the homeowner's here too.
Yeah.
Yeah. What I really want to know is that no other tree matches the description you have on this piece of paper.
No, sir.
Okay. Thank you.
Mr. Buckley?
This letter here is based off of your first drive through brief level 1 that you did, right?
That's correct, yes, sir.
Okay. Thanks, I just wanted clarification.
Okay. Any other questions?
No.
Thank you.
Thank you.
I have a question for Mr. Ferris. Thanks.
Mr. Ferris?
My question has to do with, based on what was left of the tree, what the parts that you examined later, is any of that consistent with what's in this letter as far as the condition of the tree, as far as did you see anything where there were open cavities or insects inside, the disease inside the tree, anything like that?
No, excuse me, no, and that's what, aside from when I first read the letter, when I was on the site, first thing that caught my attention was that it said rear property. As I went further down, realized it wasn't the right species, the size wasn't correct. And then I read further in, there were no numerous cavities. What's left of that, there are no visible cavities there. What the debris that was on the property next to it, the large limbs, there were no cavities on there. So I didn't see any of that on this tree. So that's what kind of
Right.
sent up red flags at the time.
So, in your professional opinion, would you consider this to be a health, not now, but I mean, prior to the cutting?
At that time, I would have,
A healthy
yes,
tree?
yes, yes.
And you would not have recommended or allowed it to be cut even as late as October 3rd or whenever it was, after you, it would
Yeah,
not
no, I
be a
wouldn't.
candidate for cutting down?
No.
Okay. That's all I have. Thanks.
Any other questions, Mr. Ferris?
I have a procedural question,
Okay.
not Mr. Ferris, but a procedural question. You know, normally we make the motion, then we have deliberation. Is that the way we're gonna go tonight?
Well, no, I suggested that this case, in light of the fact that you're going to have to make a determination as to the applicability of section 163.045, probably is a threshold question. I would recommend that you do, when you close the hearing, do deliberations first.
Any other questions of any other witness?
I do have actually, Mr. Quilling, sorry for calling you back up. We've heard under oath 2 different stories of this letter, and that was one that you zoomed in on a photo that you got and made this, based on that. And you also said that you were there in person. Did you do this inspection in person?
I did.
Or did you do it based on a photo that you zoomed in that someone gave you?
No, I've seen the photo, and then I did the level 1 inspection.
Okay,
of the
so
tree.
you did both
Yeah,
then?
just so I
Okay.
knew which one it was.
Gotcha. That's all, sorry.
No problem.
Yeah.
Any other questions of any other witness? There being none, at this time, we're going to close the public hearing.
Well, I think they want closing arguments.
Oh,
and
that's right.
It has always
That's right.
been
I'm
your procedure to also have statement from the public if there is anyone here to speak.
I'm sorry. It's late. Who's going to,
Do you want to, I'm thinking that probably any comment from the public first and then finish it up with the closing statements would be my recommendation.
any public? Okay. You've been sworn in, correct?
I have. How you guys doing? My name's Jonathan Lee. I'm a certified arborist. My ISA number is FL6805A, and I am also a track certified arborist. There's been a lot of debate on this new law since it's passed. It's become very political, and there's a lot of, in my opinion, political bias amongst local municipalities against this law because of home rule. And my opinion is it's clear that they don't like the law, right? The local governments, local municipalities are not in agreement with the law being passed through the state. And since this law is passed, it's been an uphill battle, and we've had to do a lot of due diligence with the ISA. Me personally, I've done a lot of due diligence with the ISA. The CEO of the Florida chapter, ISA Norm Easy, we've had numerous conversations about this law, the intent of the law, the interpretation by the ISA of this law. And I've had numerous conversations with the lawmakers, Mike LaRosa, Anthony Sabatini, about the intent of their law, because their language in the law is very subjectively written by most people's standards, right? So what's defined as dangerous? Well, if you look at Black's Law Dictionary, dangerous is defined as something that can cause damage or loss. So in theory, by a tree's existence, it is a low risk. There's a risk, right? So by its very existence, and this doesn't come from me, this comes from Norm, the CEO of the ISA. And if I may, can I play something from my phone from the panel discussion that we had with the
I
ISA?
object that it's not relevant to the decision that needs to be made by the board tonight.
So it comes directly from the CEO of the ISA about his understanding or his interpretation of the law. So I feel like it would be relevant.
Discussion has been on whether these reports met ISA standards. So I think it is relevant.
I can't cross-examine this person. It seems to be offered for the truth of the matter asserted. It's hearsay, and I have no way to cross-examine. I don't even know who this person is.
And hearsay
So-
specifically allowed under your rules. You give it the weight you either think it deserves or doesn't deserve.
All right, so I'll repeat if I'm not allowed to enter this recording, but I wanted you guys to hear it directly from the CEO of the ISA. So his interpretation of the law is that this is a relationship between the arborist and the homeowner, right? So if I come to your property and I meet with you and I lay out the facts of the tree to you and I assess it, and I may say it's a low risk, I may say it's a moderate risk, a high risk, an extreme risk to fail, or an extreme risk to cause some other kind of damage. Ultimately, the decision rests with the homeowner. You decide, it's your property, and this law is clearly titled Property Rights House Bill 1159. Ultimately, it is the decision of the homeowner to make the decision about what level of threat they are willing to tolerate on their property, okay? So that was the initial panel discussion that we had on July 16th, and I believe Mr. Quilling was there as well, although we don't know each other, and we didn't know each other before tonight, nor have I met Daryl before tonight. What I would assert in that is that this this law, obviously it's got to go through motions to really get down to the core of what this law is. And this law is about property rights. If you're a property owner on a residential property, you have some say-so in what level of risk you're willing to tolerate. So if a seemingly theoretically healthy tree, which they fall all the time, right? I see personally, and I have thousands of pictures that I could show as evidence that healthy trees do and can fail. But we also have a professional responsibility. So I dug a little deeper, and I went to the track class, and I passed it with a 92%, my track certification class, and I really wanted to peg it down. So I asked Norm again in front of a class of 40 people, and I said, I want to know where the ethical boundary and the professional boundary is when it comes to this law. And he said, okay, Jonathan, you want the line. You want the ethical boundary. And I said, yes, I really do. I want to know that I'm acting as a professional and that I'm treating the ISA in an ethical manner. Based on some threats from other local municipalities, I feel it's important for me to do my due diligence and to get that boundary. And he said, okay, this is what I would say. If a tree is low risk, as a professional, you should walk away from it, okay? If it's moderate, high, imminent, whatever, then it's the decision not on me. I'm not out there to encourage you to take down a tree. You may have a tree that's a laurel oak and decline, it's hazardous, it's falling apart, and I've got a client that meets this description. And that client wants to save the tree. So my goal is to serve the client. And I'm going to do everything I can to save the tree. I'll cable it, I'll eliminate, hazardous limbs that I feel like are an imminent threat, and we'll do everything we can to preserve the tree. But if that client says to me, I want this tree out, well, that's an easy one, right? The tree's it's in bad shape, it should come out. I do a lot of new construction, and they do what's called alternative foundations. They do a suspended floor plan. It's a standard thing now. If you go to the city of Tampa or most other local municipalities, Hillsborough County, if you're building a house typically within 10 to 15 feet of a protected tree, they make you do a suspended floor plan. A lot of times we'll air spade it to evaluate the roots that are in that zone, but in most situations within the proximity of a house, if the tree is within that proximity, they require you to do a suspended floor. So they put in pillars and they float a foundation over that root system to avoid this type of situation, damage to the tree and cracks within the foundation of the home. I see it all the time. As a certified arborist, I've seen it 1,000 times where the roots, if you're within 2 to 3 feet, if that tree is within 2 to 3 feet of a structure, in all likeliness, if it's not currently damaging the house, there's going to come a time where that tree is going to cause damage to the house. Okay. We also look at, go ahead, sorry.
Your time is up, your 3 minutes.
Oh, okay.
You're actually over 4.
Oh, really?
So, yeah.
Okay. Can I make one last statement? Or that's it?
Well, you finish your thought, but keep it short, because I'm going to cut you off.
All right, I don't want you to cut me off. All right. Sorry, I'm trying to squeeze in as much as I can here in 3 minutes. So I just want to read something from the lawmaker when I asked for some clarification on it, and I'll make this real brief. As made clear, this comes from Anthony Sabatini, co-sponsored the bill. As made clear by the bill's plain language, the local government no longer plays any role in either determining the tree as dangerous or the owner's decision to remove a dangerous tree. The designation of a tree as dangerous is made solely by the arborist or landscape architect in their professional opinion and expertise. It is not to be supplemented, controlled, or affected in any way by local government. It is my opinion that the Florida legislature has expressly preempted local government from requiring a notice application approval permit fee or mitigation when the owner obtains the proper documentation for a tree's removal. So I'll just end it there. But I appreciate y'all's time. Thank you very much.
Any other public comment? There being none, or it's rebuttal time. It's closing argument time.
Thank you. Whether or not the tree is damaging the property is not the issue tonight. If you were the board that was issuing permits to remove trees or to remove dangerous trees or to determine whether a tree is causing damage to a property, if that was you, then it would be relevant, but you're not. The whole issue tonight is whether a certified arborist, had issued an opinion about the tree, not any tree, the tree that was being cut. And I don't disagree with Mr. Crawford as to what the statute says. It's a tiny little statute. Doesn't seem that much thought ever went into it by Mr. Sabatini or whoever wrote it, because it's really, really short, without a whole lot of definition, no definitions in it. But what it does say is that the local government may not require a permit for removal of a tree on residential property, and we have residential property, there's been no dispute about that, if, there's a big little word in there, if the property owner obtains documentation from an arborist certified by the International Society of Arboriculture that the tree, not any tree, the tree, presents a danger to persons or property. We don't have that opinion here. We have an opinion about a laurel oak that's 28 inches in the backyard. There was no testimony that this arborist ever even went into the backyard. He barely went by the house at all when he gave his opinion. He did a drive-by and ultimately results in the killing of a tree. This was like a drive-by shooting. He didn't aim, he didn't look, he didn't do anything but drive by. He couldn't possibly have even seen the cracks in that wall that isn't a structural wall. It's not a danger, even if there are cracks in that wall. Is it a danger? That apparently, and according to the citizen who got up and decided to give you somebody else's opinion that he heard, you're not supposed to question it. But the statute doesn't say that you can't question it. And what Mr. Sabatini or whoever says now doesn't matter. What matters is what is written. And Mr. Crawford was trying to tell you during his opening that what is in the statute is important. And if it had said in the statute that the local government cannot ever question the most bogus arborist's opinion ever, it would have said that. It would have said that the government has to accept any opinion from a certified arborist without question. But it doesn't say that. And levels of danger, there's been a court opinion, not a appellate opinion, but it was interesting that it said that pretty much any tree can be a danger. And if we're supposed to base it then on the homeowner's level of comfort, if you're afraid of birds and the tree happens to attract birds, then the tree is the cause of now your discomfort because it's attracting birds. And we could just clear cut every tree in every yard because it could drop a pine cone on somebody's head one day. And surely, as we know, any tree under the right circumstances can blow over in a hurricane. Are we going to cut all the trees for fear? But the point is here that on the day that this tree was cut, they didn't have that arborist's opinion, that documentation from an arborist that said that the tree they cut was a danger. I don't know what tree they were talking about. There could have been a mistake in the opinion. After the fact is too late. Coming in and going back to the property after the damage is done to now fix your very negligent opinion is too late. The tree was cut, and on the day the tree was cut, the arborist's opinion did not address this particular tree. Why it didn't address it? Well, you heard from the witness. He didn't even go up to look at it. And all of his assessment of danger was based on things that people told him. According to the citizen, we're supposed to just accept wherever he gets his information and his opinion is sacrosanct. And that's what Mr. Crawford is going to tell you, that the city cannot question anything. Their position is going to be that this statute completely cuts out the local government, and we can't question even the worst opinion from an arborist. Should we not question that he's certified? We're not arguing here that he's not certified, but surely there is room for question. At some point, when somebody sees something happening that doesn't seem right, as Mr. Anisi did, and he made the appropriate call, the government needs to come in, because we do care about our trees. We need to be able to come in and just at least say, do you have the proper documentation? Because how would we know that we're not supposed to require a permit? It tells us we may not require a permit if they obtain documentation about the tree. Clearly, there is room within this statute, and it is not precluded anywhere in there, that we get to at least ask a question. And here we did. We were shown, Mr. Anisi and Mr. Ferris were shown this approval documentation that Mr. Johnson felt he had. Mr. Johnson never even read it. How would he even know whether he had the documentation? He never read it. Mr. Khan never read it either. So the issue here is that we have somebody cutting down trees, a homeowner and a tree cutting service, and they don't even know whether they have the proper documentation. As I said, the statute is very simple. There's no need to struggle with its language. There's no need to even look at court opinions on how you interpret something. This thing is so rudimentary, it's really easy. But our position is that this statute they're using as their defense. Our position is it simply doesn't apply here because the documentation didn't exist. If Mr. Quilling's opinion had been a doctor's opinion, the tree should be suing him for malpractice. This is a matter of life and death for trees. There's no room for this kind of negligence, drive-bys and wrong kinds of trees. The arborist for the city said it's easy to tell the difference between a laurel oak and a live oak in his professional opinion. This is a matter of life and death. Negligence is not acceptable. Thank you.
Thank you.
Well, I can't agree with a lot of that, but I can agree with what she started with. Ms. Sichon said the issue that's before you is not whether the tree is dangerous or not. That's absolutely true. Under both scenarios that I gave you in the opening, and I'm going to briefly talk about now, the respondent wins this case under both scenarios. The first is that the report doesn't matter. She said I would say that, and I am going to say that because the language of the statute is just plain. It says you get a report certifying the tree, we'll talk about that in just a minute, as dangerous by an ISI certified arborist, and that's the end of the discussion. The city can complain the arborist if they think he's negligent and try to take action on his license. The city can go to the legislature and try to change the language, but the statute as it's written right now does not allow the city to examine the arborist report, disagree with it, and then say that the statute doesn't apply to have a permit. And I know that's a legal conclusion. I've certainly given you my opinion. You can certainly ask your attorney, who's a very knowledgeable and experienced attorney in this regard, and then you guys are going to have to make some kind of decision on that. Even if you decide that you can, the city's defense to our defense that there was simply a mistake of the tree, they don't argue at this point. They're not arguing whether it's a dangerous tree or not. They're not arguing that our arborist opinion can be rebutted by the city arborist opinion or 20 other arborist opinions and then overruled, and therefore the statute doesn't apply. They're arguing that the tree did not have a report written about it. The report was certainly not perfect. I'm going to agree with all of the comments from the board regarding the report, and we've talked to Mr. Quilling and our client about that. Before this hearing tonight, one might be able to reasonably conclude that it wasn't the right tree, or that he didn't look at it, or any of the things that were alleged by the city. There's one person who can testify about that, and he testified unequivocally and straightforward tonight that it was exactly the same tree. There's no other tree on the property that could be confused with. He looked at a photo of that only tree when he went out to examine it. He examined the tree a second time after it came down. So the idea that he has focused on the wrong tree and written a report on the wrong tree has been rebutted in the evidence many times tonight, and specifically by the only person who can answer that, who's Mr. Quilling. He testified as to the mistake, as to the rear or the side of the property, the DBH estimated by the vines and the growth, and the type of the tree. One, he just fessed up to an actual mistake regarding the rear or the side of the property in the report. It is written incorrectly. The DBH, from the point he estimated or viewed the tree, it was impossible to get an exact estimation of the DBH. He estimated the best he could, and he admitted tonight he was low on that, and he probably agrees with the city's 36 inches. He admitted that it was difficult to determine the type of the tree. He also said if it is a live oak tree, it doesn't change his assessment at all. He wrote a report on the correct tree. It's not a perfect report, but it's both untouchable by the city under the legal terms of the statute and supportable by the evidence that we presented today by way of clarification by the testimony of the very guy who wrote the report. And with that, I'd be happy to try to answer questions or give it to you guys and do the best we can.
Any follow-up questions? There
Thank you.
being none, we're going to close deliberation,
Close the-
the
no,
public,
Thank you.
close the public hearing
yeah.
at this time, and the board will deliberate. However,
If I may.
first thing I want
Oh,
to
sorry.
cover is this ordinance, the county organization and intergovernmental relations, the text of 163.045. Do we believe that this statute meets all our criteria, all standards?
Let's be careful. And again, I had conferred with the parties prior to this, and they both felt that this determination as to the applicability of this statute in this situation was important for this board to make. So therefore, your threshold question is actually, was there documentation from a certified arborist that the tree that was cut down presented a danger to person or property?
Okay, any discussion?
Yeah, if I may.
David?
So, after sitting through nearly 3 hours of testimony, it's my opinion that without the testimony, I would absolutely positively agree that they cut down the wrong tree. Nothing in this particular letter, this documentation that's supposed to be the permit, establishes that the right tree, by any sense of the imagination, was cut down properly. However, we have heard lots of testimony tonight from Mr. Quilling, and whether that testimony is self-serving or the actual truth, we don't know, and we have to assume it's the truth. To me, that confuses things for me a little bit. Because we now have somebody saying, yeah, I made a mistake, no, that was the right tree, I looked at it twice, I got a closer look at it, it should have came out. Again, I think if the rule of law is the one piece of paper that somebody said, that's undated, by the way, I would say that they cut the wrong tree down, because that's not what this letter says you should be cutting down. But all the testimony tonight kind of confuses things. I do have a question for the city, just for my clarification. The city is looking for $7,200, is that correct?
If you're going to, I think we need to if you're going to do this, I think you need a motion from the board
I
to
just-
reopen the public hearing, to bring to
Any
ask
more
any
testimony?
questions.
Okay, that's fine. I'll just assume that what's on this piece of paper is correct. We don't need to open the public hearing. So, again, I say that to my colleagues here because I want to hear what you guys have to say, because I don't have an answer right now. Again, I think if all you did was, if all we had was a piece of paper that came to us and said, make a decision, I'd say they cut the wrong tree down. But there has been lots and lots of testimony tonight by our arborist that says that, you know, what he's saying is wrong, and by him saying that he looked at it twice, and no matter how you slice the pie, it should have came down. So I'd like to hear from you guys to kind of help me make a decision.
So I think in many cases, we're in agreement, and my question basically comes down not to whether the tree was healthy, was the tree on this paper the same tree? And there's a lot of confusion. That's why I asked if there was any other tree that could be mistaken for it. Now, people make mistakes, and we can argue that the document's what it is. If there was another tree in the back of the house or another tree on the property that was similar to a 28-inch laurel oak, that you could obviously say, well, you were talking about this tree, then I would say there was no question. But for me, the fact that there's no other tree that it could have been indicates that this was the intended tree. So knowing that people make mistakes, it's the same address. It was discussed by the homeowner, by the tree company. Everybody discussed that tree. Nobody discussed another tree. So to me, it appears to be, I might say it's sloppy on the arborist's point of view, but my opinion of the arborist is not at question here. The statute to me says if an arborist says that a tree is dangerous, that's all that's needed. I don't agree or disagree with the law. So that's kind of where I'm sitting at. And not to say that I can't be persuaded, but that's where I'm at now.
Okay.
Mr. Snelling.
Yeah, I have to say that I agree with both you two gentlemen, your assessment.
That's not helping.
Well, I'll clarify it a little bit maybe.
Speak.
I just,
A little closer.
okay. I feel like the process of deciding to eliminate this tree was, it stinks, basically. I don't think it was I think the initial assessment was probably done quickly, and it doesn't, it just stinks to me. However, the way I read this law is that if indeed it's the tree that everyone seems to think it was, and I tend to lean towards believing that they did get the right tree. I don't think I really don't believe that it was that there's some other tree on the property that was intended to be cut down. That doesn't make sense to me. So I just feel like legally our hands are tied. I don't like the process. I just don't know what else to say. All right, thanks.
I'll go now.
Go ahead.
It seems to me that we're talking about the same tree, and in the statute it states the tree. I think separately, Mr. Quilling did a very negligent job in his job. This letter's pretty terrible. If I got this, I would be upset. And alternatively, the gentleman that hired Mr. Quilling, or the person cutting down the actual tree, to not read the document he gives you is pretty bad also. But that being said, I think we're talking about the same tree. As bad as it is, we have a letter, which is the qualification. I think it's been met. And as much as I hate it and that the tree is gone, I think according to the statute that we have that document and we're not arborists. I know who I think is probably the more qualified one, but that's not why I'm here. So, yeah, that's where I stand. The definition of the tree, if it's the same tree, if it was a different tree, if we saw that there was another size tree on the property and that I thought we were talking about a different tree, I'd say, okay, this letter therefore doesn't matter, and we don't have a letter. And I would be comfortable finding them, but as bad as the whole thing was, I see the letter here. So the qualification of the statute seems to be met, in my opinion, of course.
And we are talking about statute 163.045.
Correct, yeah.
Which I very much disagree with. It's something we're stuck with now. It appears to be written by arborists and not state lawmakers, but while in cahoots. So whenever you remove the local jurisdiction from something as extreme as cutting down trees in the city, because Temple Terrace is a tree city. And now, because of this little bit of blue ink, it's blue here on this paper, anyone can cut down any tree in Temple Terrace. Is this what you're stating? This is what the state has done to us. It's wrong. And we should have arborists standing up for it, not cutting down trees. I can understand why you're probably cutting this tree, because it is too close to the house. But it's not the tree's fault that it's there. But I really would like to see arborists. We got a tree cutter and 2 arborists, 3 arborists here tonight, that they go and try and do something about this. Our city government has to, but we need backing of people that write letters. It's a shame. It really is a shame. And with that, I move on. Is there any other comment? I call for a motion.
When we read that motion,
Who's going to hold the nose?
I want to make sure I'm going to the right
I
one.
don't think we have a motion that covers this.
That's what I was, yeah.
So I believe we're going to have to wing it, but I think really what your motion is going to end up being is, again, whether or not there was a violation of this code based on, I guess,
A violation of the state statute?
or preemption or
Yeah.
prohibition by the
Yeah.
state statute.
Yeah, and.
I mean, all I can do is tell you, give it your best shot. I can't make the motion
Yeah,
for
no,
you.
I get it, and before you make your motion, I just want to say one more thing. I wholeheartedly agree with our chairman. I think this was, this particular letter is I'm not going to say what I really think it is. But in the end, the way the law is written and the way that everybody was talking about the same tree, this appears to be enough. I don't like it. I think it stinks. It's horrible. But this appears to be enough. So I guess, the motion has to be surrounding around whether or not there was a violation of this particular statute, not our statute, the state statute. No?
We would disagree. We've cited an ordinance violation. We would ask for a motion as to whether there was a violation of our ordinance. our ordinance requires that a permit be obtained in order to cut a tree, a protected tree. Nobody's been cited under a state statute. The statute is their defense. But we ask for a motion as to whether there was a violation of the ordinance as cited, the same way you would make a motion on any other case. Obviously, you would take into consideration their defense as to whether the violation occurred.
And may I respond, since she got to see something that, I'll try to be shorter than her, I promise. I don't completely disagree with that, but the motion could be easily that you find a violation of the city statute that is preempted by the state statute, and therefore there can't be an enforcement action or a fine or a finding of violation. I don't mind you saying that we cut the tree down without the permit, because we absolutely did.
Well, and that gets to my confusion, is that we have a state statute that says you can do it, unless you got an arborist letter. Does that make our statute for, our requirement for a permit null and void? Do we need to make a motion to, is there, the fact that the state passed this law that says all you need is an arborist letter, and this is probably the worst piece of crap arborist letter I've ever seen in my entire life, does that make our requirement for a permit now null and void? Because they have a letter, they have a letter that says the tree's a danger. It's,
Then we would say that there would be no if you feel that the terms of the statute are met, then we would feel that, I don't feel that, but I would say that that the vote would be no, that there is no violation of our ordinance. There is no city statute in play here. It's a city ordinance, and the state statute is their defense that they did not need to comply with the city's ordinance. So perhaps the motion would be that we move that the defendants were not in violation of the city's ordinance requiring a permit.
And if I can, I think I agree with that. I mean, in the one aspect of this case that both parties know has troubled me is the application of this law is really judicial in nature. So I think that Ms. Shoshone's suggestion is probably the best motion, type of motion that this board, quasi-judicial board, can make.
okay.
Mr. David, would you?
No, it's all him.
Okay.
He started.
Well, no, I mean, I think there's the important distinction in that are we taking into consideration this legislation to make our decision, or are we only saying, did they violate Temple Terrace law? And I would ask you, I suppose, because that's a huge distinction.
Well, again, in light of all the facts you've taken in, you've weighed, and in light of what you know that this ordinance, or I'm sorry, the state statute says, based on that, I think your best motion as a quasi-judicial board is a determination of whether or not your city code regarding the cutting of trees, 8-, is it 28 or? 12. I'm sorry, that's right, that's the one you said, 12-768A1 was violated.
Do we have a copy of that?
You have it.
Yeah, that was handed out, it was the second thing.
It was passed out, you have it, but,
I'm sorry.
but again, I have, before the motion's made, I have to voice my concern here, because in my singular view, yeah, they didn't get a permit. That violates the city of Temple Terrace's rules, they didn't get a permit.
They admit to that much.
But are they excused? That's the question.
Okay, well, if
Are
yeah.
they excused by the virtue of meeting the statute? All of the criteria of the statute, are they excused?
Very poorly, but I'd say yes.
But you gotta make a motion.
Yeah.
I have to agree. So are you clear on that?
We're counting on you, Judge.
Oh, are you waiting for mine?
We're waiting for you, yeah.
Or
or David.
I mean, it seems clear to me that they violated Temple Terrace's laws.
Yeah.
But it also seems extremely clear to me that, based on this, that they met the state's requirements. So,
Well, let me give it a shot, okay?
yeah, I mean,
Let me give it a shot. So I would move in case number 19-5586 that the respondents, Amir S. Khan and, how do you pronounce the other one? Sabat J. Khan, and Fix It by Johnson Tree Company LLC, violated section 12-768 subsection A subsection 1, unlawful tree removal. However, because of the state statute number, let me find it. State statute 163.045, that there be no fine assessed.
Second. By Mr. Buckley?
Somebody, you don't like it?
I'm sorry, I don't. I
Okay.
apologize. A finding of an actual violation means that my client could be found a repeat violator if another one comes. There's other consequences beyond that. And my view is, if you find it's the same tree and the state statute requirements are met, it preempts application of your law. So it's slightly reworded, I don't have a problem with it.
Well, here's the thing, he's not gonna be cited again on that tree.
Yeah, if
Because
the
that
tree's
tree's
gone,
dead.
you can't get
That
cited
tree's
on it.
gone. If he does it again on a different
But
tree,
if he's found to have violated the city code by cutting down a tree without a permit, and he does it again, it could be found a repeat violation. I'm definitely not in favor of actually
well,
finding in
I
violation.
understand where you're coming from, but the intent here is this, he didn't get a permit for this from the city.
Well, then let's say it that way.
So he
did-
violated-
Factually, he cut the tree without a permit. However, it isn't a violation of the city ordinance
No, it
because
is. It absolutely is, because he didn't get a permit. The city ordinance says,
Then
the city ordinance is still an ordinance.
then I'd ask you to ask your attorney for help again. I'm sorry.
I'm afraid
I
I'm
agree
going to
with-
agree with Mr. Crawford on
And I do
this.
too.
Okay.
So the
So
thing
it's-
is.
it's
I'll
either
try-
they're-
I'll try this one more time. If you make a motion that they violated the city ordinance, and you can just leave it at that, and you can vote yes or you can vote no. The state statute says a local government, and now I'm stuck arguing their position, but it says a local government may not require a permit if the property owner obtains the documentation that the tree presents a danger, which means that you would feel that you would, if you think that they've met the statutory requirements, we can't require a permit. Therefore, if we can't require a permit, they didn't violate the ordinance. If you feel that they did not meet the statutory requirements and that they did not have the documentation at the time the tree was cut, not later, not based on Mr. Quilling's testimony, but at the time the tree was cut, if they did not have the documentation set out in the statute at the time that the tree was cut, then you would vote that they did violate the ordinance.
See, I disagree, because we have two opposing things here. We have a city ordinance that says you have to get a permit.
Yes, but we lose when it comes to a state
Yes.
statute. State statute's always here, we're down here. So when it comes to who wins, state statute always wins over city ordinance.
Are we being
I'm
asked to
reluctant-
opine a
I'm
state
reluctant to
statute,
do
though?
so, but I will suggest a motion, having heard how the board feels. And is that you may want to move that the respondents failed to get a permit as required by the city code.
Okay.
However, there is no violation because of the application of Florida statute 163.045.
I'm fine with that.
You-
I'm good.
Yeah.
Okay, all right, we'll do that.
I think the distinction between what you said and he said is
Yeah,
that
you
you're
found a
saying a
violation,
violation.
but no fine.
Okay.
So- Yeah, it's a small distinction, but I suppose.
Okay, so the motion would be that we find that the respondent, Amir S. Khan and Sabat, is that right? J. Khan, and Fix It by Johnson Tree Company LLC in case number 19-5586 violated the city ordinance.
No, failed to
Failed
obtain a
to
permit.
obtain a permit.
As required. by
As
the-
required by the city ordinance. However, because of the state statute 163.1045, there is no violation.
Second.
Any discussion? Any further discussion? All in favor?
Aye.
Opposed? Nay, no nays.
Awesome.
Thank you, sorry for the length.
No, it's okay. What are we gonna do about the rest of it?
Do we need another break?
This is yours. That's yours.
We gotta talk about people's grass now?
Hey, Amir. We're gonna have
Well, quite two
McDonald's
times
for
nothing is
breakfast.
still nothing.
Egg McMuffins for breakfast.
That's okay.
Exactly.
But it's
Except theirs are during the day.
That's a beautiful tree in Boston, so I'm not happy. No, no,
There are arborists that are working with the ISA and with those legislators right now. Me personally,
I hope so.
working with legislators to apply track language that define the law. So just so you know, I'm on both sides. I save trees, I take them down, I do.
Who promoted the legislation in the first place?
Somebody has to. Mr. Chairman? Mr. Chairman?
Mr. Chair.
Move along. Mr. Chairman, we have other cases that have to be heard.
We need to get going. Thank you.
We have other cases.
All right.
Okay.
Next case, please.
Okay, Jose, you're up. Case number 19-4841, City versus Ayman El Jabali for the property located at 8108 Rivermont Way. Case is before the board based on alleged violation of section 12860, inoperative vehicles, outdoor storage equipment. Case will be prosecuted this evening by Officer Jose Silva. City has evidence of the notice of violation and notice of hearing were properly served.
Good evening, board members. Jose Silva, Code Compliance Officer. This case originated proactively August 27, 2019. My inspection at the time noted a Mercedes parked in the driveway with an expired tag. This time I left the door hanging with a compliance date of August 30, 2019. My inspection on September 4, 2019 revealed no change. Notice violation was completed with a compliance date of September 14, 2019. No one was home, so I posted notice at the front door as well as City Hall and mailed copies both certified and regular mail to the address of the registered owner. During my inspection on September 18, 2019, the Mercedes tag was replaced with a current tag, but there was a Cadillac in the driveway with no tag. I re-inspected the property October 10, 2019, and the Mercedes was parked in the driveway with an expired tag, and the Cadillac now had a current tag. This time I'd like to submit photographic evidence taken by me on October 10th, 2019.
Without objection, the evidence will be admitted into the record.
Exhibit number 1 is going to be the notice posted at the front door. Exhibit 2 and 3 are going to be the Mercedes with the expired tag. This time the property is in compliance. I'd like to submit an affidavit of compliance, and I'm asking for a finding.
Without objection, the evidence will be admitted into the record. And be it noted that the respondent is not present. Any questions? There being none, I call for a motion.
I'll make a motion. In case number 19-4841, City versus Ayman El Jabali, I move that the city has proven by greater weight of the evidence the following violations of the City of Temple Terrace City Code did exist on the property located at 8108 Rivermont Way. This motion is based on the sworn testimony this board has received from the code enforcement officer, along with any other evidences, including photos, affidavits, and notice of violation, all of which is received and entered as part of the record of the hearing. I further move there be no fine imposed because the violations were brought into compliance prior to the date of the hearing.
Second.
Second by, way over there?
Brian, take it.
Mr. Hubert. Next case, please.
Oh, we
Did
gotta
they vote on it?
Can we
Oh.
vote first?
Well, it better be good.
I'm ready to get out of here, too.
All in favor?
Aye.
Opposed, nay, no nays.
Okay, next case.
Ugh.
Case number 194898, City versus Salma Properties LLC for property located at 10043 North 52nd Street. Case is before the board based on alleged violation of Section 12816 operative vehicles, outdoor storage equipment. Case will be prosecuted this evening by Officer Doug Allen. City has evidence that the notice of violation and notice of hearing were properly served.
Good evening, Mr. Chairman and board members. Doug Allen, Code Compliance Officer. This case originated by me on August 22nd, 2019. My inspection on that date revealed an inoperative vehicle in the driveway with a flat tire and no tag. I left a door hanger with a reinspection date of September 10th, 2019. My reinspection on September 11th, 2019 showed no change, so a notice of violation was prepared on that date with a compliance date of September 17th. I posted the notice on the site, and the notice was also posted at city halls, and copies were mailed, both certified and regular mail, to the address of the owner of record. Upon my next inspection, I observed that the vehicle was no longer in the driveway, and I started to bring the site into compliance, but observed that the vehicle was now relocated to the fenced backyard without a tag or flat tires still. A notice of hearing was prepared on October 22nd, 2019. The case was scheduled for the November Municipal Code Board meeting. This time, I'd like to submit photographic evidence of the site taken by me on September 17th, 2019.
Without objection, the evidence will be admitted into the record.
Exhibit number 1 shows the posting of the notice of violation. The site is still out of compliance, and I am requesting a ruling.
Say still out of compliance?
Out of compliance, yes.
Any questions? Mr. Allen? There being none, call for a motion.
I'll make the motion.
David?
In case number 19-4898, City versus Salma Properties LLC, I move that the city has proven by greater weight of the evidence the following violation of the City of Temple Terrace City Code exists on the property located at 10043 North 52nd Street, Section 12-860, inoperative vehicles, outdoor storage equipment. This motion is based on the sworn testimony this board has received from the code enforcement officer, along with any other evidence, including photos, affidavits, and a notice of violation, all of which is received and entered as part of the record of this hearing. I further move that said violations be corrected on or before December 11, 2019. If respondent does not comply with this order on or before that date, they order to pay a fine for each and every day the violation continues past the date set for compliance. Upon consideration of the following factors: 1, gravity of the violation; 2, any actions taken by the violator to correct the violation; and 3, any previous violations committed by the violator, I move that the fine be $50 per day.
Second.
Second by Mr. Buckley. Any discussion? There being none, call for a vote, yeah.
All in favor, aye.
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 All right. Everybody's looking, and I'm thinking, what?
Our next case, case number
Feed 'em after
195006,
midnight.
City versus Peter Schumacher for the property located at 9619 North 55th Street. Case is before the board based on alleged violation of Section 8102 18A, minimum standards, sanitation shared area. Case will be prosecuted this evening by Officer Doug Allen. City has evidence that the notice of violation and notice of hearing were properly served.
Good evening again, Mr. Chairman and board members. Doug Allen, Code Compliance Officer. This case originated proactively by me on September 5th, 2019. My inspection on that date revealed unmanicured vines on the exterior walls. I left a door hanger with a reinspection date of September 10th, 2019. My reinspection on September 23rd showed no change, so a notice of violation was prepared on that date with a compliance date of October 1st. I posted the notice at the site as well as at City Hall, and copies were mailed, both certified and regular mail, to the address of the owner of record. My reinspection on October 21st revealed that the site was not in compliance, so a notice of hearing was prepared on October 21st, 2019, and the case was scheduled for the November Municipal Code Board meeting. This time, I'd like to submit photographic evidence of the violation taken by me on October 21st.
Without objection, the evidence will be admitted into the record.
Exhibit number 1 shows the violation posting, notice of violation posting, and exhibit number 2 shows the vines on the exterior wall. At this time, the site is in compliance, and I'm submitting an affidavit of compliance, and I'm seeking a finding.
Without objection, the evidence will be admitted into the record. Are there any questions? There being none, I'll call for a motion.
I'll make a motion.
Mr. Buckley.
In case number 19-5006, I move that the city has proven by a greater weight of the evidence the following violations of the City of Temple Terrace City Code did exist in the property located at 9619 North 55th Street. This motion is based on the sworn testimony this board has received from this code enforcement officer, along with any other evidences, including photos, affidavits, and notice of violation, all of which is received and entered as part of the record of this hearing. I further move that there be no fine imposed because the violations were brought into compliance prior to the date of this hearing.
Second.
Second by David. Any discussion? There being none, all in favor?
Aye.
Opposed? No nays.
Okay, next case, case number 19-5011, City versus Jose R. Asensio and Magalis A. Asensio for the property located at 8013 Terrace Ridge Drive. Case is before the board based on alleged violation of Section 8102-13B, exterior walls, maintain in good repair, Section 1035, sanitation abutting property. Case will be prosecuted this evening by Officer Lori Smith. City has evidence that the notice of violation and notice of hearing were properly served.
Good evening, Mr. Chairman, board members. Lori Smith, Code Compliance. This case originated proactively on September the 6th, 2019. My inspection revealed exterior wall staining on the right and left side of the structure, and the sidewalk was heavily stained with mildew. At that time, I left a door hanger with the compliance date of the 20th of September, 2019. My inspection on October the 1st, 2019 revealed no change. Therefore, a notice of violation was prepared on the 2nd of October 2019 with the compliance date of the 14th of October 2019. No one was at home, so I posted the notice at the front door, and I requested copies be mailed certified and first-class mail to the address. I also requested a copy be posted at City Hall for the 10-day requirement. My inspection on October the 14th, 2019 revealed no change. At this time, I would like to submit photographic evidence that was taken by me on the 14th of October 2019 showing the violations. Exhibit 1 shows the notice letter posted at the front door. Exhibit 2 shows the exterior wall staining on the right side. Exhibit 3 shows the exterior wall staining on the left side. Exhibit 4 shows the sidewalk staining.
Without objection, the evidence will be admitted into the record.
Mr. Chair, may I ask a question to Lori?
Yes.
Hey, that sidewalk, is that public or private property there?
That would be public.
It's public,
It's
so-
abutting. The sidewalk abuts the property, so it's the responsibility
I
of the
understand.
resident.
Similar to the ditches that are over on.
Correct.
Even though it's public property, they have to maintain it and clean it and stuff? Okay, thanks for that.
Kind of like the same thing. No problem. At this time, I would like to submit an affidavit of compliance, and I'm just looking for a finding.
Good.
Without objection, the evidence will be admitted into the record. Note that the respondent was not present in this case, in case 195011, and in 195299. Are there any questions? There being none, a call for a motion.
I'll do it. You want to do it? Go ahead.
No, I'll do it.
Okay.
In case number 19, in case number 195011, I move that the city has proven by a greater weight of evidence the following violations of the City of Temple Terrace City Code did exist on a property located at 8013 Terrace Ridge Drive. And the code sections violated were section 8-102, subsection 13, subsection B, and section 10-35. The motion is based on the sworn testimony this board has received from Code Enforcement Officer Lori Smith, along with any other evidence, including photos, affidavits, and the notice of violation, all of which is received and entered as part of the record of this hearing. I further move that there be no fine imposed because the violations were brought into compliance prior to the date of this hearing.
Second.
Second by David. Any discussion? There being none, call for a vote. All in favor?
Aye.
Opposed? No nays.
Okay, case number 195299, City versus Abel Pino Lopez for the property located at 5307 Rainbow Drive. Case is before the board based on alleged violation of section 12860 and operative vehicles, outdoor storage equipment. Case will be prosecuted this evening by Officer Jose Silva. City's evidence and notice of violation and notice of hearing are properly served.
Good evening, board members. Jose Silva, Code Compliance. Case originated proactively September 19, 2019. My inspection revealed the yard grass to be overgrown and the vehicle parked in the driveway with no tag. This time I left door hangers with compliance dated September 22nd, 2019. My inspection on September 24th, 2019 revealed no change, so a notice of violation was completed with a compliance date of October 4th, 2019. No one was home, so I posted notice at the front door as well as City Hall. Also mailed copies both certified and regular mail to the registered owner. During my inspection on October 4, 2019, I found the yard grass cut, but the vehicle still without a tag. This time I would like to submit photographic evidence of the notice posted at the front door and the vehicle in the driveway with no tag.
Without objection, the evidence will be admitted into the record.
As of this time, the property is in compliance. I'd like to submit an affidavit of compliance.
Are there any questions, Mr. Silva? Without objection, the board will accept. It will be admitted into the record. Is the air on?
I'm batting cleanup.
We've gone past the time.
No, it's on. There you go. It just kicked on.
Must be 80.
Probably lowers it. They probably lower it to like 80 or something, or up it to 80.
Are there any questions of Mr. Silva?
No.
And call for a motion.
I'll make the motion. In
David?
case number 19-5299, City versus Abel Pino Lopez, I move that the city has proven by greater weight of the evidence that the following violations of the City of Temple Terrace City Code did exist on the property located at 5307 Rainbow Drive. Violation of Section 12-860, inoperative vehicles, outdoor storage equipment. This motion is based on the sworn testimony this board has received from the Code Enforcement Officer, along with any other evidence, including photos, affidavits, and a notice of violation, all of which is received and entered as part of the record of this hearing. I further move that there be no fine imposed because the violation was brought into compliance prior to the day of this hearing.
Is there a second?
A second.
Second. Bill Snelling. Any discussion? There being none, call for vote. All in favor, aye.
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 Opposed, nay. No nays.
Okay, next case, case number 195606, City versus MUPR3 Assets LLC for the property located at 8531 Renaud Boulevard. Cases before the board based on alleged violation of Section 1034, sanitation keep premises clean, and Section 8102, 14A, fences maintained in good repair. Case will be prosecuted this evening by Officer Jose Silva. City is evidence that the notice of violation and the notice of hearing were properly served.
Good evening, Jose Silva, Code Compliance. This case originated from an HOA complaint on September 20, 2019. I was provided with a phone number of an investor who was purchasing the property. I contacted that investor and advised him of the curbside debris by the curb and the damaged fence. He advised me that the curbside debris will be cleared by that afternoon. My inspection on September 25, 2019 revealed no change and notice violation was completed with a compliance date of September 30th, 2019. During my re-inspection on October 7, 2019, I discovered a change of ownership. This time I completed a second notice of violation with a compliance date of October 17th. No one was home, so I posted notice at the front door as well as City Hall. Also mailed copies both certified and regular mail to the registered owner. My inspection on October 17th revealed the curbside debris still present in the side yard fence in disrepair. This time I would like to submit photographic evidence taken by me on October 17th.
Without objection, the evidence will be admitted into the record.
As of today's date, the fence has been repaired and the curbside debris cleared. I'd like to submit an affidavit of compliance asking for a finding.
Without objection, the evidence will be admitted into the record. The respondent is not present. Are there any questions? Call for a vote?
Motion first.
Call for a motion. Come on.
Who wants
Call
the
for a
last
motion,
one?
Long night.
I'll go ahead.
please.
In case number
Ryan.
19-5606, I move that the city is proven by a greater weight of evidence of the following violations of the City of Temple Terrace Code did exist on the property located at 8531 Renault Boulevard and sections 1034 and 8102 subsection 14 subsection A. This motion is based on the sworn testimony this board has received from the code enforcement officer, along with any other evidence, including photos, affidavits, and the notice of violation, all of which is received and entered as part of the record of this hearing. I further move that there be no fine imposed because the violations were brought into compliance prior to the date of this hearing.
Second. Second by Mr. Plow. Discussion? There being none, all in favor?
Aye.
Opposed? Nay, no nays.
Okay, take us home here. Okay, case number 19-4186, City versus Judith Valdez Cugat. We're at unfinished business now. For the property located at 6109 Oak Fern Court, an affidavit of noncompliance was submitted by Director Brony for Section 8102-13C, dated October 10th, 2019. Case number 19-4518, City versus Genus Miller III LLC for property located at 12702 North 53rd Street. The deadline for compliance is tonight at midnight. Case number 19-4940, City versus Robert and Lisa McNeil for the property located at 9406 Hidden Ridge Place. Deadline for compliance is tonight at midnight. And I have 4 cases not on the agenda that are in compliance. So these liens are now in compliance. So case number 19-0924, City versus James B. Burns for the property 602 Courtney Drive. An affidavit of compliance was submitted by Officer Silva for sections 81022 and 81021, dated June 3rd, 2019. Case number 19-1924, City versus Craig Brunstein for 418 Ferncliff Avenue. An affidavit of compliance was submitted by Officer Silva, date for section 12901, dated October 10th, 2019. case number 05-50557, City versus Jeffrey L. and Vertica Roads for the property located at 708 Grand Circle. An affidavit of compliance was submitted by Officer Silva for Section 11.129.9 and 25755.10, dated October 29th, 2019. This was a property transfer as a result of the final judgment of foreclosure. And case number 19-1236, City versus Judith Valdez Cugat for the property located at 6109 Oak Fern Court. An affidavit of compliance was submitted by Officer Smith for Section 8-102-13H and 10-3B, dated November 13th, 2019.
This is great. I love compliance. It's a good thing. You guys have done really well out there.
And then before we end, just that item on new business, we just have to make sure everyone's available for that meeting.
What is that?
January 7th.
January 2nd?
2020.
7th.
7th, okay, it was
At
January
5
2nd.
At 5 p.m. And this is with council.
Yeah. That's a Monday.
So we'll be meeting with council to
Back here probably, or here.
to discuss policy on lien reductions and
And lien releases.
New
As far as I know, I can make it.
Yeah, me too.
Please all do. Please, please, please.
I'll send a confirmation email tomorrow since tonight's so long.
Okay, with that, if there's any other issues you want to discuss, call for a motion to adjourn.
So moved.
Second by Stone.
strong third.
All in favor?
Aye.
Opposed, nay, no nays.